But then if you get a mail, then you also get a right. Yes, we could have moved it there, it can be downloaded. Just have to click on it and download.
How do I send message?
ಕೇಂದ್ರದಿಂದ ಬೃಂದಾವನ್ ಕೇಂದ್ರದ ಹತ್ತಿರವರೆಗೆ ಸೋನ್ಸೋ ತಂತಿಯನ್ನು ವಿ ಸ್ಟ್ರಿಂಗ್ ಬಳಸಿ ಭಾಗಶಃ ಕೇಬಲ್ ಬಳಸಿ ಸೋನ್ಸೋ. ದೆನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಸಿ ನೆಲಮಂಗಲ ಕೆವಿ ಸೋನ್ಸೋ ಹತ್ತಿರ SSC ಕಾರಿಡಾರ್ ಉಪಯೋಗಿಸಿ ಸ್ಥಾಪನೆ ಸದರಿ ಮಾರ್ಗವು ನೆಲಮಂಗಲ, ಅರಿಶಿನಕುಂಟೆ, ಮಲ್ಲಾಪುರ, ಶಿವಪುರ, ಸೋನ್ಸೋ 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 ಪೀಣ್ಯದಿಂದ ಹಾದು ಹೋಗುತ್ತದೆ. 400 kV 220 kV ಸರಬರಾಜು ಪಡೆಯುವ ಸಲುವಾಗಿ ಹಾದು ಬರುವ ರಾಜಾಜಿನಗರ ಏಕಮಾರ್ಗವನ್ನು ಜೋಡಿಸಲು ಹಾಲಿ ಇರುವ 220 ಕೇಬಲ್ ಕಾರಿಡಾರ್ನಲ್ಲಿ ಪ್ರಸ್ತಾವಿತ 220 kV ಕೇಂದ್ರದವರೆಗೆ ಸೋನ್ಸೋ ಕ್ರಾಸ್ ವರೆಗೆ ಹಾದು ಹೋಗುತ್ತದೆ. ಹಾಲಿ ಇರುವ ದ್ವಿಮಾರ್ಗವನ್ನು ಸಹಕಾರ ನಗರಕ್ಕೆ ಜೋಡಿಸಲು ಬೃಂದಾವನ್ ಲೀಲೋ ಪಾಯಿಂಟ್ ಬಳಸಿ ಪ್ರಸ್ತಾವಿತ 220 ಸೋನ್ಸೋ ವರೆಗೆ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೇ ಸಿ 0.18 ವರೆಗೆ ಭೂಗತ ಕೇಬಲ್ ದ್ವಿಮಾರ್ಗ ಸ್ಥಾಪನೆ ಸದರಿ ಮಾರ್ಗವು ಪೀಣ್ಯದಿಂದ ಹಾದು ಹೋಗುತ್ತದೆ. ಸೊ ಅಪ್ ಟು ಪೀಣ್ಯ they are malot using that underground cables. Also malot next line ರಾಜಾಜಿನಗರದಿಂದ ಐಡಲ್ ಕಾರಿಡಾರ್ಗೆ ವಿದ್ಯುತ್ ಸಂಪರ್ಕ ಪಡೆಯುವ ಸೋನ್ಸೋ ಪಾಯಿಂಟ್ ಬಳಿಯ ಸೋನ್ಸೋ ಬಳಿಕ ಎಂಟಿಟಿ ಆಫ್ ಪ್ರಸ್ತಾವಿತ ಸೋನ್ಸೋ ಭೂಗತ ಕೇಬಲ್ ಏಕಮಾರ್ಗದ ಸ್ಥಾಪನೆ. ದೆನ್ malot ನೆಲಮಂಗಲ ಕೇಂದ್ರದಿಂದ 220 kV ಮಾರ್ಗಕ್ಕೆ ಸೋನ್ಸೋ ಕೇಂದ್ರದವರೆಗೆ ಭೂಗತ ಕೇಬಲ್ ಹಾದು ಹೋಗುತ್ತದೆ. So in these three stretches malot they are using bhugata cable. All that I am asking is there is a PIL also pending malot before this honorable court that school galu matte most malot hospitals where children and malot these large gatherings gather, they have agreed that underground cables be laid. Now malot there is one selective kind of ಕೆಲವರು ಈ ಅಫ್ಲುಯೆಂಟ್ ಏರಿಯಾಗಳಲ್ಲಿ ಹೆಚ್ಚು ಜನದಟ್ಟಣೆ ಇರೋ ಏರಿಯಾ ಅಂತ ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡೋ ಏರಿಯಾಗಳಲ್ಲಿ ಭೂಗತ ಎನಿವೇ ದೇ ಆರ್ ಡೂಯಿಂಗ್ ಇಟ್ malot. And all this cost is passed on by KERC to the intended consumers. This is all industrial line. Because of the industrial areas in that region, my lord, the upgradation is happening. All that we are praying is, I will, my lord, argue the matter on merits. There are legal points. Pending that, if they agree that in my stretch also, my lord, because it's a school, if they lay underground cables, I will not press anything to service.
Sir, now
There and my lord, the core issues will not, these issues that I have raised, the legal issues that I have raised, my lord, are not the subject matter of consideration. That's a suo motu PIL, some incident happened, my lord, that's all. But I am core issue involved here is whether KPTCL has powers to lay the line, whether under the act they have been given powers. That is all, my lord, on the core of the Electricity Act, I have raised the issue, even including the license expiry of KPTCL, whether at all, my lord, that can be considered as a licensee, deemed licensee, continuing license, all that are not issues here. But I am not pressing anything to service. If they say that my school, as far as my school is concerned, there is no PIL. I am only saying in ನನ್ನ ಸ್ಕೂಲಲ್ಲಿ ಇವರು ಅಂಡರ್ಗ್ರೌಂಡ್ ಕೇಬಲ್ ಹಾಕ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರೆ ಮಕ್ಕಳ ಸುರಕ್ಷಾ ದೃಷ್ಟಿಯಿಂದ I will not, rest of the issues I will not press.
They find their counter. The counter is not a file. That the way that
And they,
the subject line that my friend has also appeared in the connected cases case that has been delegated to the deputy commissioner. They examine all these aspects in contract. They were given to file objection. The deputy commissioner, in two cases has been limited back to the deputy commissioner and 16 one of the Telecast.
No.
Which is pending for consideration.
No,
And
that,
also examined with regard to the compensation. That was meeting was fixed on 4/7, it has been adjourned.
There, the public notice was, my lord, questioned. Only public notice. Here, my lords will say, section Allah, annexure A is questioned. Their notification.
That is from the.
Allah, whether, my lord, the constitutional validity of section.
I filed the detailed objection, there is a interim order in favor of them. That I filed detailed objection.
Adre, Badur. Yes, interim order is, my lord, not to disturb my.
Yes, not to.
ಏನ್ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಿದ್ರ
ಅಲ್ಲಿ ಬಂದು ತೆಗೆದು ಅಲ್ಲಿ ಮೇಲ್ ಲೈನ್ ಹಾಕ್ಲಿಕ್ಕೆ ಹೋಗ್ತಾರೆ. ಅಂಡರ್ಗ್ರೌಂಡ್ ಕೇಬಲ್ ದೇ ಕ್ಯಾನ್ ಲೈನ್.
ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಲೈನ್ ಇದೆ ಅಲ್ವಾ
Existing line illa, dead line. That is all, my lord, the whole issue. Lordships may see, it's a dead line. There is no line.
I saw indicate there was a line running across your.
No, they say, my lord, that there is a corridor. They don't say intelligently, they say corridor. There is no line.
If there's a deadline, where's the question only laying an underground?
ಅದನ್ನೇ ತೆಗೆದು ಈಗ ಲೈನ್ ಹಾಕೋದು ಅಂತ. That, my lord, lordships will see a line was laid, no compensation was paid, nothing was made. In 60s or 70s, my lord, some line was put. That is not energized. Now, subsequently, what they are doing is using the same corridor and they will now string the new lines. Now, this will be energized. This is the issue. And, my lord, more importantly, there are options, multiple options available, including the underground cable and aerial bunched cables. Without exploring them, now, my lord, the central government also has come out with new guidelines how to approach these kind of affluent, the populous areas and how not to disturb the ಜನರಿಗೆ ಡಿಸ್ಟರ್ಬ್ ಆಗದೆ ಹೇಗೆ ಲೈನ್ ಹಾಕ್ಬೋದು ಅಂತಿದೆ. ROW issues ನ ಹೆಂಗ್ ಸಾಲ್ವ್ ಮಾಡ್ಬೋದು ಅಂತಿದೆ. All guidelines are there. Let them file the counter.
Representation to them to.
No, the virus of this notification itself is challenged. Annexure A, whether that sweeping power can be conferred.
Objections.
Yes, grateful. Interim order. Great.
Cinema 50.
Interim order make that. Interim order make candidates. Great.
Appearing for the petition. Kindly have it next week, ಮೇಡಮ್. ಸ್ವಲ್ಪ ಓದ್ಬೇಕಿದೆ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಅಬ್ಸಲ್ಯೂಟ್ ಇದೆ ಇದ್ರಲ್ಲಿ. Cinema 51, ಶ್ರೀಮತಿ ಸುಧಾಡಿ.
Mr. Petitioner, though I am ready, the other side has informed that the learned council has some health issue.
Cinema 52.
Your lordship,
In this case,
for
in
petition,
this case, I applied for this phone number 2, man.
it may kindly be passed over, your lordship.
Have it next week, madam.
51.
Very well.
Yes, your lordship.
56. Cinema 53, ಶ್ರೀಮತಿ ವಿದ್ಯಾ.
Appearing for the petitioner, my lord. This writ of mandamus filed by the petitioner. They filed objections as well. My lord, in the year 1984 itself, I got a license
What is the mandamus for?
to allot a shop, my lord, in under APMC.
Not a shop.
Yes, my lord.
You had made an application.
Yes, my lord. My lord, a brief facts, my lord. In the year 1984 itself, I had a shop. As per, I got a shop, my lord. I was running the shop. I was selling potato and onions in that shop. In the year 2000, due to an unfortunate fire accident, my shop got destroyed. From there on, I've been giving representations and applications. However, they're not considered to this effect.
Allotment under, was it on a lease basis?
Yes, my lord. License was given, my lord. After that incident, my lord, my shop got destroyed.
When was the incident? 2000?
2000, my lord. In the year 2000. My lord, thereafter, I've given multiple representations, my lord. To that effect, they even considered that, my lord, kindly look into annexure. R1, 2, 3, 4, 5, 6 annexures.
R1.
Yes, my lord.
Your writ petition?
Yes, my lord. In my page number. From my lord 71 onwards. My lord, wherein they have asked for certain documents, my lord. Whatever I had, I gave, my lord. The only thing they're asking.
They had asked for residence certificate, shop being burnt photographs,
Yes, my lord.
they to obtain agreement.
In
order
that
copy.
one document, we do not have, my lord. It got destroyed in fire. Whatever we had, we gave. They even accept the fact that we had a shop.
Then situation is that 2000 the shop was not. After we thought of the occupancy. 2005 we issued a transaction that since you have not produced that, case cannot be considered. Thereafter, in 2020, he has produced some documents. Then we have passed a resolution, annexure R5, 24 to 2021. That two shops were burnt at that time, shop number 69 and shop number 70. Shop number 69, the alternate shop is allotted. So therefore, on that consideration, he should also be allotted a shop. Shop number 28/31 was recommended to be allotted, and the recommendation was sent to the director. Director again sent back letter and asked for some more documents, which we have provided on 1/6/2021 as per annexure R11.
ಆಮೇಲೆ ಏನಾಗಿದೆ?
ಅಲ್ಲಿಂದ ನಮ್ಗೆ ಇನ್ನೂ ಬಂದಿಲ್ಲ. The approval has to be given by the director ultimately for allotment.
Directly government affairs,
Director ನೀವು party ಮಾಡಿಲ್ಲ.
My lord, if I may, my lord. All this while, they've never brought up this point at all, my lord.
It is stated by the Karnataka Council APMC that a resolution had been passed on 24/2/2021, recommending allotment of shop number
28/31 in Coconut Block.
in favor of the petitioner in lieu of the shop number 70, which had been burnt in the year 2000. And in response, certain documents were sought for from by the director, and the same has also been furnished.
ಬಂದ್ಬಿಟ್ಟು ಹೀಗೆ ಹೋಗಕ್ಕೆ ಶುರು ಮಾಡಿ. ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಮಲಾಡ್ ನಂದು ಇದ್ರೊಳಗೆ ಟವರ್ ಅದೆಲ್ಲ ಪ್ರತಿಯೊಂದು ಬಂತು ಅಂತಂದ್ರೆ ಸ್ಮಾಲ್ 35 ಗುಂಟೆ ವಿಲೇಜ್ ನೊಳಗೆ ಇದು ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಐ ಆಮ್ ಸ್ಟಕ್. ದಟ್ಸ್ ವೈ ಐ ಕೇಮ್ ಬಿಫೋರ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್. ದರ್ ಎಂಟ್ರಿ ಮಾಡ ಆಮೇಲೆ ಎಂಟ್ರಿ ಮಾಡೋದು ವೆಕೇಟೆಡ್ ಸಬ್ಜೆಕ್ಟ್ ಟು ದ ರಿಸಲ್ಟ್ ಆಫ್ ದ ರಿಟ್ ಪಿಟಿಷನ್ ಫಾರ್ 3 lakhs compensation. They are fixed. I have not of course availed anything. All these days they were not doing anything. Suddenly ಮಲಾಡ್ they have started ಅದನ್ನ ಡಿಗ್ಗಿಂಗ್ ಶುರು ಮಾಡಿದ್ದಾರೆ.
ಲೈನ್ ಆಗೋಗಿದ್ರೆ ಇನ್ನೇನ್ ಮಾಡೋದು?
ಹಾಕೊಂಡಿಲ್ಲ ಇನ್ನು. ಅದಕ್ಕೆ ಸಬ್ಜೆಕ್ಟ್ ಅಂತ ಇತ್ತು ಸ್ವಾಮಿ. ಸಬ್ಜೆಕ್ಟ್ ರಿಸಲ್ಟ್ ಅಂತ
petition.
ಅದು ಸಡನ್ಲಿ ಮೇಲೆ ಅದು ವೈ ಆಲ್ ದಿಸ್ ಚೇಂಜ್ ಅಂತ ಸೀದಾ ಹೋಗ್ತಾ ಇರೋದನ್ನ ಅವರೇ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. ಅರ್ಲಿಯರ್ ಕವರ್ ಆಗಿದ್ರೆ ಮಲಾಡ್ ಐ ಹ್ಯಾವ್ ನೋ ಕೇಸ್. ನೋಡಿ annexure E ನೊಳಗೆ ನನ್ನ ಸರ್ವೆ ನಂಬರೇ ಬರೋದಿಲ್ಲ, 198 ಇಲ್ಲ, 11 ಇಲ್ಲ.
Now that the line has been laid, you want
Yes,
me to,
Malad.
now that the line has been laid, you want me to direct them to set aside, remove the,
ಹಾಗೆ ಆಗಿರೋದು ಇದ್ರೊಳಗೆ.
interim order vacate ಮಾಡಕ್ ಬಿಡಬಾರ್ದಾಗಿತ್ತು.
ಅದೇ ವೆಕೆಟ್ ಆದ ತಕ್ಷಣ ಸಬ್ಜೆಕ್ಟ್ ಅಂತ ಇತ್ತು. Course, if I am correct, that's what my Mr. Basaraj told me. Subject to result of the petition ಅಂತ ಇತ್ತು. ಅದು why this change was required ಅಂತ. Only to Milad ಅವರು ಬೇರೆ ಯಾರಿಗೂ ಅನುಕೂಲ ಮಾಡೋದಕ್ಕೋಸ್ಕರ ಈ ತರ ಮಾಡೋದು. Day one ಇಂದನೇ if that is the survey, my lord, and it goes via
condition of the petitioner that without notifying his land, the lines could not be drawn in his line, in his land. An interim order was also granted to the petitioner on the said submission. However, the respondents appeared and submitted that a corrigendum had been issued to annexure E, including the land of the petitioners, and therefore the interim order came to be vacated. Then counsel appearing for respondent is also submits that pursuant to the vacation of the interim order, a line has also been laid on the land of the petitioner and the compensation has also been assessed. In my view, in the light of
3 lakhs
both
ಅಂತ
facts,
ಮಾಡಿದ್ದಾರೆ.
no useful purpose would be served by entertaining this writ petition, reserving liberty to the petitioner to seek for enhancement of compensation. If so advised, the petition is dismissed.
Number 55. Number 56. Sharat S. Gowda. Sharat S. Gowda.
Since the removal of work has been completed.
Or Burley or Bandaki.
Number 57. Pawan Chandra Shetty.
Advocate for petitioner, my lord.
Today that memo.
My lord,
Fiscal bills.
Lord, I am filing for memo, my lord.
What is the matter about?
My lord,
He.
he
For compensation of the.
amputation by the electrocution.
Today that.
My lord, a memo which includes,
Realist
my lord, a short date may be given, my lord.
next week.
26th.
My lord, before 26th. my lord.
I'm sitting only on Thursday, Friday for WP.
Thursday, my lord, 25th. Please, my lord, much obliged, my lord.
Number 58. Nandish Gowda GB.
I appear for respondents, my lords. I need to secure instructions and time my statement.
Number 59. Sri Ramchandra Reddy.
For the respondent. Matter, the matter is pending before the Karnataka appellate tribunal. It is posted final hearing on next week, my lord, because August 2 weeks.
Number 60. Sri Kiran J.
Lord, the government, my lord, has to say that 6A license, whether it will be granted or not. Time was granted to the state, my lord. And my submission is that, my On Wednesday, my lord, they came near the property and done the Mazar. I think another 1 week time may be required, my lord. They would came near the property and Mazar came to be drawn and they are in the process, my lord.
Released on so and so. Till then, the interim order granted earlier.
Interim order. Grateful, my lord.
Bill number 61. Srimati Shilpa Rani.
Released.
Number 61.
The interim order dated 5/7/2024 has been complied with and a demand draft for rupees 2,74,091 has been deposited. The interim order granted earlier shall continue, relist after 2 weeks.
Final hearing, seal number 62 adjourned, seal number 63. LS Rajendra Prasad.
Matter, my lords. I request for a week's time, my lords.
Released. 2008 matter.
My lords, senior is unwell, my lords.
Released.
Seal number 64, VB Sidramaya. '65, Sri Vinay Vasmat. Seal number 66, Sri Shamant Nazis.
Appearing on behalf of the respondents, my lords.
Yes.
My lords, this is a matter where fixed charges are disputed, where there is an installation where they say they will pay only for the partial supply. And we're ready to address arguments, my lords. It may kindly be passed.
My lord, the connected writ petition, the fixed electricity charges, my lord, it is already deposited. To the what extent they have deposited, my lord, they want to get the instructions. So far as first petition is concerned, my lord, the same does not survey for consideration. My lord, since my lord, the same electricity charges has been paid in the second petitioner.
66 does not survive. Huh?
It does not survey for consideration.
My lords, I may have.
66, he says it does not survive for consideration.
First writ petition.
WP 44321.
Yes. 44321.
Once the player submits that the players made in the petition not survive for consideration. According to the statement, writ petition is dismissed as become unnecessary. 66.1.
ಅದು ಅಭಿನವ್ ಅವರು ಇದು ಮಾಡ್ಬೇಕು.
Number 67. Number 68, BC Sitaram Rao. Number 69, Joseph Anthony. Number 70, Padma Asuttu.
Respondent number 126.
Next week.
Number 71, Malla Reddy PV. Number 72, Shri Sarvana S.
Let's may seek your lordship's indulgence, lords.
Yes.
Let's, I am at serial number 44, which was understood to be heard, but without even informing lords, time is taken at 10:30. This is the fourth time the matter has come before the court.
It's adjourned to 26th.
So
Somebody made a mention.
every time the matter comes without even mentioning us, lords, the adjournment is sought. Could you, lords, this is the fourth time, fifth time the matter is coming up. At the request of government, it is being adjourned. I don't know why matter should be adjourned time and again without even.
On Monday.
Lordship pleases.
With your lordships kindly, in that excise matter, the lordships granted 2 lakhs compensatory cost. And today the matter has to be listed for reporting settlement. But the matter is not listed for the
Direction plan.
ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು ಬಂದಿಲ್ಲ
ಕೊಟ್ಟಿಲ್ವೇನೋ
ದುಡ್ಡೇ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರು ಅನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡ್ರು ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಅನ್ಲೋಡ್ ಮಾಡ್ಕೊಂಡ್ರು ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ನೋಡು.
Serial number 11.
ಮಂಡೇ
ಅಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ.
Now we said the allotment later. Today morning he has signed.
Third concept for the BDA files and memo. And it closes the letter of allotment dated 19/7/2024 by which site number 3181 has been allotted to the petitioner.
Still it has to be executed.
In view of the above, it is clear that the order passed on 25th of March 2024 has been complied with. The BDA shall execute the necessary documents in favor of the petitioner within a period of 2 months.
He'll have to comply with. He'll have to comply.
No, already we are complied, my lord, we are the.
Within a period of 2 months from today.
Mutual.
2 months from the date of this compliance ಕೆಳಗಡೆ.
In compliance,
ಗುರ್ತಿಸ್ಬೇಕು. ಅವರೆಲ್ಲ relinquish
within a period of 2 months from the date on which the petitioner complies with the requirement of paying the balance consideration.
balance consideration and surrender of his revenue
What are
tax
the-
documents ಎಲ್ಲ ಮಾಡ್ತಾರೆ.
Regarding the determination of state advice concern, one of the matters went up to the Supreme Court. When the Supreme Court also held that, my lord.
He'll have to comply.
Because my lord, again, they are issued the demand notice saying that I have to pay the full entire settle amount. Because I am the land user, I will lost my site. The Supreme Court has directed the media to consider the determination of settle value at the time of putting the application. Now, my lord, they.
ಮಾಡ್ಲಿ ಆಮೇಲೆ ನೋಡೋಣ ಏನಾಗುತ್ತೆ.
ಅಲ್ಲ ಅವ್ರ ಅದೇ ಉದ್ದೇಶನೇ ಅದು ಸುಮ್ಮನೆ ಎಲ್ಲ ಮತ್ತೆ ತಮ್ಮನ್ನ ಸೆಕೆಂಡ್ ಲಿಟಿಗೇಷನ್ ಬರ್ತಾನೆ ಇದೆ.
Third concept for the BDA is directed to comply with the further requirements of executing the necessary documents within a period of 2 months. Relist the matter for reporting complaints after on so on. Please, ಏನಿದೆಯಾ ಮಾಡಿ ತೋರಿಸಿ.
Mutual.
Sir, 23rd September, sir, Mukesh sir, 23rd September.
Yeah.
2 months.
65.
ಇಲ್ಲಿ ಈಗ ಒಂದು ನೋಡಿ ಇನ್ಸು ಕಳಿಸಿದೆ ಸೇವ್ ಮಾಡ್ರು ಅಂತ ಹೇಳಿ ಹೋಗ್ತಿದ್ದೀನಿ ಅವ್ರು ಬಂದು ಕೇಳ್ಕೊಂಡ್ರಿ
Madam, serial
What is
number
language?
5 and 16.
ಎಲ್ಲೂ ಇಲ್ಲ ಬಟ್ ಅಲ್ಲೇ ತಾನೆ
ಅಲ್ಲೇ ಕೆಳಗಡೆ ಸೇಮ್ PC ಇದೆ. ಸೊ
Court officer. Court officer. Court officer. Court officer. Court officer.
Court officer. Court officer. Court officer.
ಹೇಳಿ ಸರ್.
Sir, first Kalburgi matters ಕರೀತಾರಾ?
ಧಾರವಾಡ.
ಧಾರವಾಡ. Thank you.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್. ಹೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಧಾರವಾಡ ಬೆಂಚ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ
ಹಾ
ಸೀರಿಯಲ್ ನಂಬರ್ 678.
ಏನ್ ಮಾಡ್ಬೇಕ?
ಸಾಹೇಬ್ರ ಕವರ್ಡ್ ಬೈ ಜಜ್ಮೆಂಟ್ ಸಾಹೇಬ್ರ.
ಆಯ್ತು, ನಾವೆಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಸೋಣ ಅಂತ ನಾ ಹೇಳ್ತೇನೆ ಅಂತ ಹೇಳಿನಲ್ಲ. ಎಲ್ಲ ಆಲ್ಮೋಸ್ಟ್ ಅಪ್ ಟು 16 ಮಟ್ಟ ಅಷ್ಟು ಹೋಗ್ತಾವ.
ಇವ್ ಮೂರು ಒಂದ ಕ್ರೈಮ್ನಾಗ ಅದಾವ.
ಹೌದೌದು, ಗೊತ್ತು.
ನಿನ್ನ ಮ್ಯಾಟ್ ಮುಗಿಸ್ ಬರ್ತೀಯ ಹಂಗಾರೆ ನಾನು ಹೋಗಿರ್ಲ ಮನೆಗೆ ಹಂಗಾರೆ ಅವನಿಗೆ ಅದು ಕೊಡ 6 ಫೈಲ್ ಎಲ್ಲಿದೆ ಇಟ್ಟು ಹೇಳಿದೆಯಾ 230ಗೆ 6 ಪ್ಲಸ್ 4 ಎರಡು ಟೈಮ್ ಮಾಡ್ತೀನಿ ಕೊಡ್ಲಿ ಮ್ಯಾಟ್ರ್ And 2 ನಿಮಿಷ ಕೆಲಸ ಫಸ್ಟ್ ಕಾಲೇಜ್ ಮೆನ್ಷನ್ ಮಾಡಿ
Cell number 75, 230 matter. Last time, this is the regularization matter. We had taken time, my lords, to file written submissions. My lords had said my lords will reserve it. Only one further clarification was required to be made. My lords have the other list, my lords, the Harvard list, have informed. Can it be taken on Monday, my lords? I just have 5 more minutes to submit. Please. ಏನಾರು ಹಾಕಿದ್ರೆ ಕೊಟ್ಬಿಡ್ತೀನಿ.
Monday.
Submission, my lord, insofar as the Dharwad bench matters are concerned.
Yes.
Am I audible to your lordships kindly, my lord?
Yes.
My lord, matter at seal number 21 pertaining to the Dharwad bench. I
Really?
request your lordships to have it on second.
ಯಾವ matter ಹೇಳಿ?
Matter seal number 21, my lord.
21.
Vishwanath Badiger is the advocate on record.
All right.
I request your lordships to have it on second. I'll come physically for them.
I'll be in Kalburgi for you to come. Kalburgi ಬರ್ತೀರಾ?
ಆಗ್ಬೋದು my lord, ತಾವು it will be a pleasure. 22nd ಆಗಲಿ.
ಆಯ್ತು.
Please.
Positive on matter, seal number 23.
Oblige, my lord.
Thank you.
10761. Petition.
Which is the first matter?
8587. 8587.
This is filed by the husband. First petitioner is father-in-law. What about the other petition?
That's 5517. Father, wife.
Separate crime ಇದು.
Millets, one is filed by the wife, Millets 498A. That is first petition, Millets 9587. Second petition is 5517 ಅಲ್ಲಿ ಅದು ಬೇರೆ crime number.
Father-in-law is the company.
Other father-in-law had lodged complaint against
Now who's Baburao?
father of the wife.
Husband.
Bigger man ಹಾಕಿದ್ದು. ಅಲ್ವಾ? ಇದೇನ್ ಅಲಿಗೇಷನ್? ಇದ್ರಲ್ಲಿ ಏನ್ ಅಲಿಗೇಷನ್ ಇದ್ದಿದ್ದು?
ಮನೆಗೆ ಬಂದು ಗಲಾಟೆ ಮಾಡಿದ್ರು ಅಂತ. ಗಲಾಟೆ ಮಾಡಿ ಪ್ರಾಣ ಬೆದರಿಸಿ ಹಾಕಿದ್ರು. CC number 51278 of 22.
lakhs ಕೊಡೋದಾ?
Yes, Millets. ಅದರಲ್ಲಿ 5 lakhs already ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. Another 16 lakhs Millets will be paid. They have filed a petition before Chennai court for mutual consent divorce. There at end ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ. They have agreed for total 18 lakhs.
ಮಕ್ಕಳು?
No issues.
One petition conjugal rights ಇದೆಯಾ?
Also, all those petitions, Millets, C, D, E and G, all these petitions have been already withdrawn by the parties. ಅಲ್ಲಿ ಚೆನ್ನೈಯಲ್ಲಿ ಒಂದು ಡಿವೋರ್ಸ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು, ಅದು ಬಿಟ್ರೆ ಆಗಿದೆ. ಆಮೇಲೆ ಒಂದು ಕಾಂಜುಗಲ್ ರೈಟ್ಸ್ ಹಾಕಿತ್ತು, ಅದು ಬಿಟ್ರೆ ಆಗಿದೆ. ಮೇಂಟೆನೆನ್ಸ್, DV ಆಕ್ಟ್, ಆಲ್ ದ 4 have been withdrawn.
Para 11 ಏನು ನಂಗೆ ಅರ್ಥ ಆಗಲಿಲ್ಲ. Para 11. Here you say 18 lakhs and 5 lakhs is paid, 13 is to be given. Alva?
Total amount is 18 lakhs.
Then what is this para 11?
Para 11.
After we received 16 lakhs and an additional 2 lakhs.
Yes. They have exchanged the articles, Millets. 2 lakhs gold was missing.
Total 18 lakhs.
Total 18 lakhs. Total 18 lakhs. Let's para 2, Millets. Para 2 is clearly mentioned. The respondent.
Because here you talk about 18 lakhs, 5 lakhs paid now,
Yes,
13 lakhs balance. ಇಲ್ಲಿ 16 ಲಕ್ಷ ಬಂದಾದ್ಮೇಲೆ ಅಂತೀರಾ, ಅಂದ್ರೆ ಇನ್ನು 13 ಲಕ್ಷ ಕೊಟ್ಟಾದ್ಮೇಲೆ
ಇಲ್ಲ.
16 ಲಕ್ಷ ಅವ್ರದ್ದು ಸೆಟಲ್ಮೆಂಟ್ ಅಮೌಂಟ್, 2 lakhs ಆರ್ನಮೆಂಟ್ಸ್ ರಿಸೀವ್ ಅಮೌಂಟ್, ಟೋಟಲ್ 18 lakhs ಅಷ್ಟೇ. 18 ಅಲ್ಲಿ 5 lakhs ರಿಸೀವ್ ಮಾಡಿದ್ವಿ, ಇನ್ನ 13 lakhs ಬ್ಯಾಲೆನ್ಸ್ ಬಂದಿದೆ.
Which is mentioned at para 2 minutes. It's clearly mentioned.
you are the wife. You agreed for this? What have you done? Studied? You understood the contents of the compromise? How much are you receiving?
Paid for 5 lakhs. And they have agreed to 13 lakhs last week. I checked.
The criminal petition 9587/2021 arises out of a complaint lodged by the wife against her husband and her in-laws. Criminal petition 5517/2022 arises out of a criminal complaint lodged by the father-in-law against the wife and her relatives. So today, a joint compromise memo is filed in both these petitions, the terms of which read as follows. The husband and wife are present before the court. The wife admits the execution of the compromise petition and also submits that she has received a sum of rupees 5 lakhs and is agreeable to receive the balance sum of rupees 13 lakhs as indicated in the joint compromise memo. You know the fact that the dispute is essentially between two families which arose out of a marital dispute. In my view, this would be an appropriate case to accept the compromise memo and quash the proceedings pending before both the proceedings, that is proceedings in CC number 29688/2021, pending on the file of the 6th ACM Bangalore, and also CC number 51278/2022, pending before the 10th additional Chief Metropolitan Magistrate Bangalore. Petitions are accordingly resolved. Multi signature committee.
Much.
What is this 10761?
10761 for fourth accused case, separate petition, same crime number.
Same crime.
Raising out of CC 5127. Okay. Criminal petition, so and criminal petition 10761.
Please.
Sign. Sign. Forward bench matters.
Please, my lord, I appear on behalf of the petitioner in serial number 1, my lord.
Yes.
My lord, pursuant to the lordship's order, my lord, they have approached the honorable apex court, challenging the order passed by staying the. This, my lord, notice has been ordered before the apex court, my lord. They have produced along with the memo.
Stay again.
ಇಲ್ಲ ಸ್ಟೇ ಆಗಿಲ್ಲ, ಬರೀ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ನೋಟಿಸ್ ಆಗಿದೆ.
I am appearing for respondent, my lord. Lordship may kindly have the look at the Supreme Court order, my lord. Whatever observation they have made on the basis of earlier order, my lord. That is, they have produced in at page 105. Now, my lord, I have produced along with memo, my lord. Lordship may have that, have a look at that order. May I read, my lord? The permission to file. Would your lordship got it?
ಇದನ್ನ ಹೇಳಲಿಲ್ಲ ನೀವು ನನಗೆ.
Please.
You did not inform me that the order passed in contempt was confirmed in SLP.
No, my lord. Contempt is recently closed, my lord. Recently it is filed. Contempt. The lordship's order was pleased to challenge by way of a special leave petition by the state, wherein, my lord, a special leave petition came to be dismissed on imposing cost without going on to the merits of the case. No liberty was reserved to us for filing a review petition, but in view of the pendency of the contempt petition, my lord, we filed a review petition challenging the order passed by the.
Why did you not tell me that SLP had been filed and was rejected?
My lord, that was brought to the notice of this lordship, my lord. SLP is filed and the lordships, no, before issuing notice, the lordship said, my lord, when already my order has been confirmed before the SLP, I will not interfere. But however, my lord, we made a submission that in view of the pendency of the contempt petition before the division bench, the lordship was pleased to issue notice. It was brought to the notice of this honorable court, my lord, by the learned AAG, my lord.
They are not mentioned regarding SLP, my lord. And
No, no, my lord. In the review petition, it is part of the review petition. SLP order is produced.
But in
SLP
detail,
order
it
is
has
produced,
been,
my lord.
in detail, it has gone into, my lord, on that day.
May I take it to lordship at annexure F, page 103 in the first petition, review petition. I have produced the copy of the special review petition.
This order is effect of that order, my lord. If your lordship go through that, my lord,
Adjourn ಮಾಡ್ಲಂಗ್ರೆ ಈಗ?
no, my lord. After vacating stay, my lord, your lordship may post it on any day, my lord.
ಇನ್ನೇನ?
After vacating stay, your lordship may post it at any day, my lord.
My lord, now they have not filed any application for vacating of. They have produced only a memo along with the copy of the SLP challenging the lordship's order.
Lordship
The
may
Supreme
kindly
Court says,
have a look.
if the Supreme Court allows your SLP, automatically the interim order will stand vacant, isn't it?
Yes, my lord, yes, my lord. But notice has been only ordered, my lord, now, as on today.
If the Supreme Court says ultimately review is not maintainable, then my hands are tied.
My lord, pursuant to the lordship's order, my lord, we have deposited whatever the admitted amount before the executing court.
It is not deposited, my lord. It is not.
Well, it is deposited. It is deposited before the executing
Only
court.
on their calculation, they have deposited, my lord.
Yes, my lord. As per our calculation only, we have admitted whatever the admitted amount we have deposited before the executing
That
court.
is disputed, my lord. Now, my lord, your lordship may kindly look at
I can't
earlier
vacate-
order, my lord.
I can't vacate the interim order because the High Court is not, the Supreme Court is not chosen to stay my order.
Yes, my
They
lord. Yes,
simply
yes.
said that my order could not have been passed because of the SLP having been dismissed. Review was not maintainable.
Yes, my
The
lord.
Supreme Court holds that the review is not maintainable, then automatically everything goes. Isn't it, Patil Rai?
Yes, my lord. That is, they will have to ask any modification before Supreme Court only.
Realist.
My lords, one submission.
I
I appear for my lords, including applicant in this case. My lords, the registry may kindly be directed to show my name on right hand side because my lords, listing of matter will not be known to me, my lords.
Who are you?
They are the beneficiaries, my lord. They are the beneficiaries.
In the name of Sri Chetan Munolli and Srimati Sulbi Kulkarni as appearing for the impleading applicants in the causes.
With your lordship's kindly, regarding interim order.
I can't do anything. There's no, I granted the interim order after hearing you.
Pardon?
I granted the interim order after hearing both sides.
Yes, my lord. Yes, yes.
Here, my lord, in pursuance of earlier Supreme Court order and the present order, my lord.
Let the Supreme Court pass the order.
Continuance of this order.
Allah, if tomorrow Supreme Court dismisses the SLP, then what will I do?
My lord, after appearance, my lord, after having, you lordship may kindly say earlier order, my lord. It is on 105 page, my lord. Next ref. They have produced, my lord.
It will come after 4 weeks, Alva.
Yes, my lord. 4 weeks anta helida.
Next week.
No, Supreme Court is going to hear the matter when?
4 weeks. 4 weeks. 4 weeks.
After 4 weeks anta helidare.
After 4 weeks.
23rd August. Seal number 5. Ravi Hegde. Ravi Hegde.
Ravi Hegde.
My lords, I appear for the respondent in this matter, my lords.
Yes.
On the last occasion, my lords. On the last occasion, my lords, I was directed to my lords to keep the divisional controller present. My lords, he is present in the court today.
line is present, my lords. Lords, this matter, my lords, I had on the earlier occasion submitted that against the order passed, my lords, in the WP number 79363 of 2013. May I request my lords to kindly see the order dated, my lords had passed an order on 8/2/2024.
Yes.
My lords, in that, my lords, this order came to be passed, my lords, on the earlier order passed by this honorable court in WP number 79363 of 2013.
Yes.
There, my lords, the writ petition was in favor of the workman. Therefore, my lords, this honorable court, looking into that order, my lords, are directed to pay the benefits that he is entitled to. Against the writ petition 79363 of 2013, my lords, we had filed an appeal. Appeal, my lords, was listed before the court. The writ appeal, my lords, was listed before the court on 12/7, and the division bench, my lords, had issued notice in that matter. Since, my lords, and we have also, my lords, issued an endorsement to the workman that we are awaiting the orders in the writ appeal.
No, there was no stay of the order, isn't it?
There is no stay of the order, my lords. There was some delay in filing the writ appeal. May I request, my lord, since notice is now, my lords, issued in the writ appeal, may I, my lords,
grant you a stay.
my lords, since there was a delay, my lords, in the writ appeal, notice has been issued.
When is it-
May I, my lords, request for
When is it relisted again?
my lords, notice is out, my lords, next date is not granted. May I, my lords, request for some 4 weeks accommodation, my lords. In that, my lords, within that we'll get some orders, my lords, from the writ appeal. I'm sorry, my lords, we ought not to have dragged this matter this long, but for the fact that when the writ petition was filed, writ appeal was already pending, my lords, and I did not bring it to the notice of this honorable court that the pendency of the writ appeal was not communicated.
Stated that as against the order passed in WP 79363/2013, TSRTC, NWKRTC has submitted an appeal in writ appeal number
1000014 of 2024. I have filed a memo, my lords.
writ appeal number.
The endorsement to the workman, we have submitted that
And the same was posted before the court on 12/7.
on 12/7.
And notice of the appeal has been ordered on the respondents. And in view of the above, the order passed by this court in the present writ petition is not implemented. So in view of the fact that the writ appeal is still been pending, post this writ petition for consideration, for further consideration, after the disposal of writ appeal number soons.
Grateful.
Serial number 6.
Serial number 6, 7, and 8, my lords,
Yes.
are covered by the judgment of my lords at criminal petition 1000588 of 2024.
My lord, I have already produced the copy of that, wherein the lordship was pleased to allow the petitions insofar as other accused persons are concerned.
Same idena.
Yes, my lord, yes, my lord. Arising out of same crime, same CC and same crime.
This petition
The first case, serial number 6, is insofar as accused number 7 is concerned, my lord.
filed by accused number 7. Mikito.
Next, accused number 4. Next, accused number 6.
Accused number 4, 7, and 6. 4, 6,
Out.
and
7, 4, and 6.
7, 4, and 6. So it is not in dispute that in respect of the same crime as against
Accused number 2, 3, 5, 8 to 13.
accused number,
Accused number 2, 3, 5, 8 to 13.
this court has already quashed the proceedings in criminal petition number 100588 alva
Howdo, the 588 of 24.
2020.
That is in respect of accused number 8.
ಮಿಕ್ಕಿದವ್ರ ನಂಬರ್
ಅಲ್ಲ ಅದು ಇದೆ 100646 of 24, 105732 of 2024 ಆಗಿದೆ ಅದು. I have gone through the judgment. I will give the numbers, madam. I will give the numbers.
So criminal petition number so and so. In view of the above, in the same reasoning, this petition is also allowed and the proceedings as against the present petitioners shall also stand quashed.
Serial number 9.
My lord, I accept notice for 1 and 2 in all the cases.
Consumer accepts notice for
1 and 2.
state. 1 and 2 cases. Number 9.
Serial number 9.
9.
Srinath Pachapure.
Weak stems continue.
Number 10, Shri Jagdish Patil.
My lord, this is offences under section 498. There are no allegations against the present petitioner who is accused number 5, my lord. Only ominous allegations. So the lordship shall, I accept notice for R1, my lord.
This is in respect of
A5, my lord, A5.
Accused number 5.
Who is the brother of accused number 1, my lord? Who is the brother of accused number 1?
who appears for the complainant.
Notice has to be ordered. It is coming for the first time, my lord.
Issue, concerned accepts notice for R1, issue notice to R2. To the next date of hearing, the proceedings as against the petitioner is concerned shall remain stable.
Meantime, I may be permitted to comply with the office objections.
Office object to comply with the meeting.
Please.
For hearing IA. C number 11. Shri
Lord, similar, serial number 11, my lord, already the lordship says, please to allow the petitions insofar as co-accused are concerned. It is at page number 148, my lord.
148.
Yes, my lord. A batch of petitions were disposed of by this honorable lordship, my lord. At 141, man, 141, sorry, man. Arising out of the same crime and the same CC number, man.
You have accused, no?
Idu accused number, my lord, 6, 7, 9, 10.
6, 7.
9, 10.
Illa, I think because come to page 148.
Yes, my lord.
154.
Yes, my lord.
That was also
150. That is different, my lord. That is different with regard to other crime. But insofar as the present case crime number is page 141. That is the first judgment passed on 20th January 2024, my lord.
Accused number yaru helidre?
Accused number 6, 7, 9, 10, 11 to 16, 18 and 21.
At page 144, it says accused number 43 and 6 and 5.
Those petitions were filed only so far those accused numbers are concerned. But the present petitioners are accused number 6, 7, 9 and so on. At page 143, CC number 13 of 2022, it is prayer, the prayer column, it is incorporated at that is criminal petition 100677 of 2022. Illa. There is a general idu ashta ide idar mele eni.
The petition is filed by accused number 6, 7, 9.
My lords, may I make a submission, my lords?
Yes.
My lords, serial number 18 is also connected to the same matter, my lords, arising out of the same crime number. And for the accused number
My lord,
1, 8 and 23, my lords.
my lord, serial number 11 to 18 are similar, arising out of the same crime and same offences, my lord. Serial number 11 to 18 are arising out of same. Lordship shall pass the same order in all the cases.
These petitions have been filed by accused number so and so. Challenging the proceedings that have been initiated against them. Offences under section 133, 147, 148, 307, 353, 153. This court, in relation to the other accused in a batch of writ petitions, had quashed the proceedings in criminal petition 100607, 100675, 100677, but 2022, on the ground that even in the charge sheet, there were no overt acts attributed to the accused therein. Even in this case, as per the governments in the charge sheet, there are no overt acts attributed against the petitioners. And therefore, on the same analogy, the proceedings against the present petitioners cannot also be sustained. Consequently, the proceedings insofar as the petitioner is concerned shall also stand quashed. 11 to 18, huh?
ಹೌದು 11 to 18 my lord.
Number 19.
My lord, in all the cases I accept notice in all the cases.
Starting consumer to take notice for responding.
Number 19, Shri B. Anwar Basha.
Then consumer.
My lord, in this case, offenses under section, my lord, ಇದು KP Act, my lord. They were playing matka and they were caught red-handed. Section 78 sub clause 3 of the KP Act.
Undisposed madidna.
ಇಲ್ಲ ಇದು identical cases, my lord, already this court has quashed the proceedings. But the present petitioner is accused number 2.
Same principle thane.
Yes, my lord, yes, my lord.
Consumer accepts notice for the respondent. The petitioner is filed challenging the proceedings initiated against the petitioner for offences punishable under section 78 3 of the Karnataka Police Act. So this court in criminal petition 100406 but 2024 has already held that the investigation had commenced even before the registration of an FIR and even before permission under 155(2) the CRPC had been obtained and had washed the proceedings in respect of accused number.
ಅವರು my lord, the present petitioner is accused number 2.
Other one
ಹೌದು.
as against accused number 1. So, in my view, on the same reasoning, the proceedings against the present accused would also have to be quashed. Accordingly, the proceedings shall stand quashed.
Please.
Further consideration, seal number 20. Sangram is concurring.
My lord, the respondent was directed to file affidavit, my lord. He has filed his affidavit.
Where is he?
My lord, he is in Dharwad. He is held up in court hall number 2, my lord.
List.
Second.
Oblige.
Please.
Kalburgi bench matters. For order, serial number 1, Shri Sachin Mahajan.
I am appearing for respondent number 1, your lordship. We have filed statement of objections. You kindly be taken after a week.
List. Move on.
9th.
All three will take it up on the 9th.
Oblige.
2:30 PM matters.
Kalburgi matters. Item 3.
9th.
9. Great.
Serial number 73, Shri Vivek Olla.
Impression was not to be created. That nothing, no amount is being paid or nothing. Just blood what must be. They are collecting. Every month, my lot see 1st of April 2021. Loss in energy was 6,52,000. Transmission losses was 20,000 both. Wheeling charges, 5% of the AWH is collected by them. Then 2% banking 12%, 12,640. Total is 44.
My order was only restricted to transmission charges, sir.
Yes, your lordship. Transmission.
Others I have not touched anything.
Yes.
Transmission.
Yes.
Because earlier you were not.
No. What I am submitting to my lordship says, an impression sought to be created as a.
They had said you were not paying transmission charges because under the earlier policy, you were exempt.
Yes.
Now, after the present regime has started, you would be liable to pay at 1,63,000 per kilowatt or something.
That we are paying.
No, that they said nothing was paid. Therefore, I said you pay 50% of it.
Alright.
That is all that I have done.
Alright.
This I have not done anything. This I have not touched.
Some impression was created, so.
Yeah, that was Only limited transmission charges.
Namdaralli, your lordship, my lord, say that because we have already entered into an agreement. Subject to my lord, the final result of your lordship.
Yes. You have to give a reply, alright?
ಹೌದು. ಆಮೇಲೆ only thing, my lord, I had already submitted 2 judgments. I'll give it to your lordship, my lord, and then I think my lord, the others will.
Yes.
I'm sorry, my lord, ಅಲ್ಲಿ ಒಂದೇ ನಿಮಿಷ, ಅದೆರಡು ಒಂದೇ ಪುಟ್ಟೆ ನೋಡಿ. ಒಂದಿದು ಒಂದದು. ಸರಿ. Thank you. Lord, R20, Lord, my lords are having Lord that Synod India Limited. Yes. Please come to Lord paragraph 20. Sorry, page 20, my lord. My lords get that at the bottom.
Yes.
Mark Madi copy. Sorry, my lord. Not Mark Madi copy.
It is true. It is true that rule 173B.
Oh, 173 has not been amended. But even if the same has been done, it would not make a. I'm sorry, my apologies.
It makes it easy for me.
Would not make a material difference as how comprehensive provision has been made in the primary act, and thus a rule frame thereafter, even in case conflict, must be with a substantive statute. Well settled principle of law that in case of conflict between the substantive act and the delegated legislation, former shall prevail, in as much as the delegate legislation must be read in the context of primary. So, it is a well accepted principle of law. Just one. Then the second one, my lord, if your lordship take. Please come to my lord, paragraph 20, my lord. My lords get that. At the last page, para 18, my lord, first row. Para 18, my lord, at page 19,
yes.
In the middle, my lord. Distinction has to be made between delegate legislation and the primary legislation named in that by the legislature. In section 49, there is no specific stipulation that the notification issue under section 49 of that can be invoked at any time, as it was the case of the Durga Oil Mills and another. Where section 6 of the Orissa Sales Tax Act itself was, my lord, this is in respect of the legitimate expectation. Now, my lord, please come to paragraph 20. Yes. Next page. In this 21st century, when there is a global economy, the question of reach is very important. Government offers certain benefits to attract the entrepreneur, and the entrepreneur act on those beneficial offers. Thereafter, the government withdraws those benefits. This will seriously affect the credibility of the government and will show the short-sightedness of the governments. Therefore, in order to keep the faith of the people, government and its instrumentality should abide by their commitments. In this context, action taken by the urban corporation in invoking the benefits of the entrepreneur in the hill area will sadly reflect the credibility and the people will not make it take the word of the government. That will shake the faith of the government. Therefore, in order to keep the faith and maintain this good government, necessary that whatever representation is made by the government or its instrumentality induce the other party to act. Government should not be conflicted with the government. Lord, why I'm saying it, there was an agreement with the government. They said, my lord, I am entitled. They, my lord, now, my lord, the rule, my lord, framed by the central government doesn't, my lord, permit, my lord, them to withdraw all this. In the, my lord, regulation which they have, which the KRC has framed, they, my lord, withdraw that and then say, my lord, banking for 1 month. That, my lord, would be, my lord, contrary to, my lord, what was represented. That's all, my lord. Other things, my lord, I'll keep on repeating. Therefore,
yes. But in the other matter, the Sindavan matter, I acted along with. May I not pay your lordships one here? That's Lord, now.
At this juncture, there is no.
Your lordships are passing interim order, my lord, your lordships in my matter.
No, I'm reserving your matter.
Okay.
Your lordship,
In my
may we
matter-
reply to the arguments taken by them. On the last date of occasion, they filed the additional statement of facts and they argued on that also. May we reply to that argument?
My lord, in my case, my lord, in Vrindavan Hydro, where similar issue is involved, where I showed, my lord, there is a government order which continues. In this, what has happened, my lord, my agreement has expired on 27th of June. Now, subsequently, the power is being delivered to the grid system. All that I am praying is, my lord, I don't have the protection of an interim order because the transmission charges 50% katti nanagal hogi anteli, the order says, my lord. But I am saying that I am entitled under the old agreement to continue that. Now, all that I am now saying is, my lord, I may be permitted to go to the interstate open access under IEX. There is an application pending before them. Till the disposal of this case, I may be permitted to sell power under IEX to interstate open access. The permission is pending. They don't object to that, my lord, normally, because there is no agreement. Today I am a free bird. Now power is going waste. I am neither getting paid, nor getting banked, nor getting, my lord, any commercial benefit out of that. There is an application pending. I have served a copy on them. May I, my lord, produce that?
Your lordship, their earlier agreement has expired. After that, if they wish to take open access through IEX, that is short-term open access, it's their right and their wish, they can do it. We have no objection. My instructions are that SLDC has registered them in NOAR. First step is to register them in NOAR, and then it is to grant them standing clearance for the purpose of open access. Or register madadmele, they have not applied for standing clearance. If they apply for standing clearance, we'll grant it as per the procedure.
Let that be recorded, my lord, my application.
Yes, in accordance with the procedures applicable for that transaction, we will do it.
ಏನಾಗಿದೆ ಇದು ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳಿ ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇಲ್ಲ ದಟ್ ಇಸ್ ದ ಓನ್ಲಿ ಇಶ್ಯೂ
ಇಲ್ಲ my instructions are that is not the case.
That is recorded. May I, my lord? May I, my lord?
Or application ಹಾಕಿಲ್ಲ for standing clearance.
ಹಾಕಿದ್ವಿ
ಇಲ್ಲ just now verify.
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲಿ ಹಾಕಿದ್ದೇವೆ ಆ ಅಪ್ಲಿಕೇಶನ್. Lordships may see, lord, annexure W. I have made a specific request as way back as 8/7/2024.
This has been allowed. They are registered also.
Without prejudice or
National Open Access Registry, they have been registered also.
ಅಲ್ಲ ನೋಡಿ, we request you to grant NOC. ಇವ್ರು NOC ಕೊಡ್ಬೇಕು. ಈಗ ಈ ಕೇಸ್ ಇದೆ ಅಂತ ಹೇಳಿ they are not, no, I know for a fact, but I normally don't make such, I'm stating under instructions that NOC is being denied. I have, let them.
It may be recorded, your lordship. They are registered on the registry. If they file an application for NOC, we will grant them. This is not the application. This is for the National Open Access Registry. The procedure requires them that after they are registered, they have to file an application for NOC, which they have not done. They are registered with the registry, Open Access Registry, NOAR. If your lordship recollect in another matter, your lordship had passed an interim order directing us to register them within 1 week. That process is complete with him. After that, if he files an application with us for the purpose of standing clearance, we will grant him.
This is
Let
the
him file.
application.
Illa, your lordship, the procedure is not this.
This is the other application that they have to file.
First is NOAR, which they file, they produce Annexure W. Annexure W, what they produce is the first application for the purpose of registration on NOAR. After this application, we've registered them. If they file an application now for NOC, we will grant it to them.
Can you consider this as the application?
If your lordship may direct, we will consider, your lordship.
May I read that application?
Because usual procedure is after they are registered in NOAR, they have to file a separate
ಅಲ್ಲ ಒಂದೇ ನಿಮಿಷ. May I read, my lord? Without prejudice, we have submitted an application.
Directing to consider this application.
Yes, as
an application for grant.
One second, Nantor. We have submitted an application on 22 and uploaded in National Open Access. The same is pending consideration.
I'm recording the fact that you have been registered.
And NOC also is applied.
That is what I'm recording.
Grateful.
And I'm also recording the state.
Grateful.
Council for. ನೀವು ಯಾರಿಗೆ ಅಪೇರ್ ಆಗ್ತಿರೋದು ಶೋಭಾಸ್?
In this matter, I appear for the respondents, all respond, except for unanimity. 4 to 10, your lordship.
Response 3 to 10 submits that as requested by the petitioner here, it has been registered and an application for grant of interstate open access is required to be filed for granting of a standing clearance. Shri Sridhar Babu Learned Council points out that by the letter dated 8/7/2024, annexure W to the application, the request has in fact been made for grant of approval / NOC to the interstate open access through IEX under the CERC regulations. In the light of the fact that the request has been made for grant of NOC to have interstate open access by the petitioner, it would be appropriate to direct the respondents to grant the petitioner standing clearance to enable him to have interstate open access within a period of
Within a period of 1 week, your lordship.
ಅಲ್ಲ 1 week, but just ಅಲ್ಲಿ ಟಿಕ್ ಮಾಡೋದಿರು.
ಎಷ್ಟು ದಿನ ಬೇಕು ಹೇಳಿ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನೀವು ಎಷ್ಟು ಹೇಳಿದ್ರೆ ನಾನು ಹೇಳ್ತೀನಿ.
3 days. 3 days, because kindly 8/7 is the date of
Subject to him
application.
complying with
It
other.
is possible at any rate within a period of 1 week.
And
ಮೆರಿಟ್ಸ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ ಇವತ್ತೇನ್ ಮಾಡ್ತೀರಾ?
ಸಾರಿ ಮಿಲೋ,
ಮೆರಿಟ್ಸ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
ಆಯ್ತು, ಹೌದು.
ನಿಮ್ದು ಆಗಿತ್ತಲ್ವಾ ಅವ್ರ ರಿಪ್ಲೈ?
ಅಲ್ಲ ಅದು ಯೂನಿಯನ್, now my lord, the other matter other than the Union of India, respondent wise we are going, lord. Union of India's I had already received the objections and I had, lord, submitted on how the rules are ultra vires. Now the regulations, my lord, how they are ultra vires the rule is this man in this way, my lord, that lordship saw, my lord, that legislative competence is lacking in the rules frame. So I'm going to the next step and, my lord, just two other steps and
It's better a year in than.
yes, yes. If on if on that threshold, my lord, that is, then other things will pale into account.
May I make one submission? I'm also appearing for petitioner in one matter. After my learned friend completes, I will have to make my submission. The only reason why I am saying this is I am fully handicapped. Central government gave me a copy of their objections. Later said we will make corrections and give you the correct copy. I made to get it. State government serves a copy at 12:30 this morning. Therefore, I am not seeking adjournment. All that I am saying is two things, Lord. One, I will make my submission after Sri Kamath completes. Number two, my Lord, permit me to file a written submission so that your Lordship will appreciate my contents.
Regulate the generation, the equitable. There are various stakeholders and authorities which are concerned with this regulation. For example, we have the central government, there is state government, there is the electricity authority, and then there are regulatory commissions. There are also three kinds of obligated entities. Firstly, we have the distribution licenses which purchase and then we have the open access consumers who are allowed to beyond a certain limit. Earlier it was if there is a load of 1 million above, a consumer could directly purchase from the market through the open access. And there are captive consumers who can generate their own and consume. But it may take a lordship to a couple of provisions to demonstrate how, Lord, all these different authorities, they do not act in watertight compartments of cycles. There is some sort of coordination. All of them act in tandem to achieve the objects of the statute. Would your lordship now have a look at section 86, which deals with the function of the state commission? The crux of the case of the petitioner is that I, as the central government, have transgressed into the powers of the state commission. So therefore, would your lordship?
The argument, if I remember him correctly, is that you have framed these rules in powers of under the powers conferred to you under section 176(2). Isn't it?
Yes.
Show me from 176(2) what is the powers that you have for framing rules.
For that, I have just three provisions to be. Not one of them is illicit. Won't take much time. But functions of the state commission. The state commission shall discharge the following functions, namely determine the tariff for generation, supply, transmission, and dealing of wholesale, bulk, or retail, as the case may be within the state. Provided that, this relates to open access. Provided that where open access has been permitted to a category of consumers under section 42, the state commission shall determine only the billing charges and surcharge thereon, if any, for the said category of consumers. So therefore, your lordship would notice that the law does not allow the state commission to decide everything about open access as far as open access is concerned. It says where open access has been permitted to a category of consumers under 42, state commission shall determine only the billing charges and surcharge thereon, if any, for the said category of consumers. So which means there is something else which may be done by any other authority.
36A confers powers on the commission to determine the tariff for generation, supply, transmission of transmission and wheeling of electricity, wholesale, bulk, or retail, as the case may be. But in respect of open access, it does not give them the power to determine the tariff for generation, supply, transmission. It only confers power on the commission for determining the wheeling charges. So that is all.
That is. Then, Lord, please have a look at section 176 now. It brings with the powers of the central government. And as power of the central government, the central government may, by notification, make rules for carrying out the provisions of these statutes. Two, in particular, and without prejudice to the generality of
that is for the purpose of this chapter.
Such rules may provide for all or any of the matter. Then, straight away we can go to Z. which is the residuary clause. So therefore, not anything that does not fit into A to Y, not as central government, I have got the power to make any rules in respect of any other matter. Then, my lord,
Is it your case that you have exercised the power under the residual power?
yes, yes, I have said under residual. Right. Then, my lord, please have a look at section 181, which is the powers of the state commission to make it. Here, your lordship, you see there are a few which pertain to open access. The state commission may, by notification, make regulations consistent with this act and the rules generally to carry the provisions of the act. So, the first emphasis that I would like to lay upon is that it says that the power of the state commission to make regulations is not absolute. It says it shall be consistent with the act and the rules generally to carry out the provisions of this act. So, which means that if the central government have made any rules, that the regulations made by the state commission must align with it. And in this case, it has aligned. There is perfect alignment. There is no difficulty. Subsection 2. In particular and without prejudice to the generality of the power contained in subsection 1, such regulations may provide all or any of the following matters, namely, in this note, what would be relevant is kindly I will look at P, clause P. Payment of, reduction of surcharge and cross subsidies under the third proviso to subsection 2 of section 42. Q. Payment of additional charges on charges of wheeling under subsection 4 of section 42. Guidelines under subsection 5 of section 42. And finally, the time and manner for settlement of grievances under subsection 7 of section 42. Now, Lord, your lordship kindly have to look at section 40. But it falls under chapter 6, titled as distribution of electricity, provision with respect to distribution license. Okay. Duties of distribution licenses and open access. It shall be the duty of the distribution licensing to develop and maintain an efficient, coordinated, economical distribution system in this area of supply and to supply electricity in accordance with the provisions contained in this act. Subsection 2 will not be relevant for our. The state commission shall introduce open access in such cases and subject to such conditions, including cross subsidies and other operational constraints, as may be specified within 1 year of the appointed date by and in specifying the extent of open access in successive phases and in determining the charges for wheeling. It shall have due regard to all relevant factors, including such cross subsidies and other operational constraints, provided that such open access shall be allowed on payment of a surcharge in addition to the charges for wheeling as may be determined by the state commission, provided further that such surcharge shall be utilized to meet the requirement of current level of cross subsidy within the area of supply of the distribution. Provided also that such surcharge and cross subsidies shall be progressively reduced in the manner as may be specified by the state commission. Provided also that such surcharge shall not be leviable in case open access is provided to a person who has established a captive generating plant for carrying of the electricity to the destination of the own unit. Provided also that the state government, not later than 5 years from the date of commencement of the Electricity Amendment Act by regulation, provide such open access to all consumers who require a supply of electricity where the maximum power to be made available at any time exceeds 1 megawatt. But this the last one specifies that where the load exceeds 1 megawatt, the state government has to provide open access. If there is a large
State commission.
the state government. State commission. Here it is state government. State government shall not later than 5 years from the date of commencement of so by regulation provide such open access to all. There never it will be state government. Unbookal state commission. Commission. Anyway, state commission. Commission or government?
Commission, state commission.
This can be very misleading. My book has government.
Provided, oh, this one.
Number 2024.
He's referring to 5th proviso, your lordship.
I am referring to the 5th proviso under section 42.
That is also state.
State commission.
Under the electricity. Provided also that. It was earlier something like now changed to. Whether it is state government or state commission, if there is a consumer who consume, I mean, whose load is above 1 million. State commission, I don't think it's state commission.
State commission.
In my book, it says government, I'm sorry. State commission. This could be wrong. This is publication of commercials.
State commission.
Anyway, Lord, for the purpose of our case, could be, I will read it as state commission. But in 2021, there was a convention, conference of various countries to which India is a signatory, where it was decided that we as a signatory that India would achieve net zero emission by 2070. And it was also resolved that various steps will be taken. And one of them would be to that we, as a nation, we will have policies which promote use of green energy. So, which is why the central government decided that there has to be a push for the generation of green energy, and a push for green energy would require a lot of investment coming in. And at that point of time, the situation prior to the introduction of these rules was that there was a lot of inconsistencies between different states in the application process as to how an open access consumer makes an application. Each state had its own, each electricity commission had its own rules. There was severe delay in consideration and disposal of the application. There was no clarity on which are the different heads of charges. Some states had their own different heads. So this was leading to a lot of confusion. There was no transparency, and all this led to huge litigation. The courts and the tribunals and the commissions were burdened with litigation. It was not a conducive atmosphere for any investor to come and invest, which is why, my lord, it was that point of time that the central government decided to achieve a few objects. The first object was to bring in uniformity in the application process. The second was to attain certainty in the regulatory process. And the third was to bring some consistency in the regulatory process, and generally to have transparency in the entire process of giving open access. And finally, the object was to bring in ease of doing business so that we get a lot of overseas investment into the green energy sector. With this objective, we set out with the framing of the rules, which is now called as the Green Energy Open Access. Lord, my learned friend has produced those rules as annexure. Here, I am having WP 22,770. If your RCP is having that, then it is page number 38. Is there any provision under the Act whereby the central government can issue a direction to either the regulatory commissions? No, I thought the scheme of the Act was the regulator is an independent body. Yes, regulate the entire process. We have not, I will demonstrate, we have not interfered with their independence at all. Under section 42. Yes. The parliament has thought it fit. Yes. To confer the power of. I will read out, there is no translation into the, we have not stepped into their domain at all. We are achieving only the 5 objects that I stated to your lordship, to bringing in some uniformity in the application process. Their power, you have under section 3, the power to form a policy. Yes. Apart from that, what is the power under the Act for you to have a supervening? No, let me read the rules first and then demonstrate how I am not overstepping into the domain of the. First, let me examine whether the power to frame the rule. Yes, under Z, I have got the power. Z is a residuary power. Yes, residuary power. It's so you can, by way of a residuary power, overrule the substantive provision. My case should be that I have not. By facts, I will demonstrate that I have not. Section 42 talks about the responsibility of the state commission to ensure that open access is provided by the distribution licensee. Yes. This power, even to determine the charges that are to be paid, is exclusively given to the regulator, state commission. Yeah, to determine the tariff. Not just that. To determine the tariff. Please read 42(2) again. Yes. I thought, it would make greater sense if I were to read out the rules first and then come back to section. I would rather that you read the substantive provision and then go to the. We have read once, I can read it once again for my benefit.
The state commission shall introduce open access in such phases and subject to such conditions as may be specified within 1 year of the appointed date by it, and specify the extent of open access in successive phases, and in determining the charges for billing, it shall have due regard to all relevant factors, including cross subsidies and other operational constraints.
So in respect of open access,
Yes,
the manner in which it will be provided, the
Yes.
extent to which it will be provided,
yes,
all factors related to open access
Yes.
is to be determined by the regulator state commission.
yes.
Where does the central government have any role to play in the matter of providing open access?
I'm not making rules for program. I have framed rules only to streamline, to bring in some uniformity.
If the parliamentary law,
Yes,
substantive provision
yes.
gives that power exclusively to the state.
176 that gives me that power.
So 176, the rulemaking power according to you overrides 40 to 40.
No, that is not my submission at all. That is not my submission at all, which is why, my lord, please allow me to read what I have done by the impugned rules and then demonstrate to your lordship how I have not overstepped into the domain of the regulatory commission. Please have a look at page 38.
38.
In WP 22,077.
You want to read the rules?
The impugned rules.
I think it's page number 68 in WP 11235. Same rules, isn't it?
Same rules. But if I may read,
Yes.
in excess of the powers conferred under subsection 1, read with clause Z of subsection 2 of section 176 of the Electricity Act, the central government hereby makes the following rules, namely, so the rules, they shall come into so definition, green energy, not obligated entities, not 2E may be necessary. Means the entities mandated under clause E of subsection 1 of section 86 of the Act to fulfill renewable purchase obligation, which includes distribution, licensing, captive user, and open access. Applicability. This rule shall be applicable for generation, person, consumption of green energy as defined under clause C of rule 2, including energy from waste to energy. Now, the first of the major rule is at 4, renewable purchase obligation. On and from the date of commencement of these rules, there shall be a uniform renewable purchase obligation on all obligated entities in area of a distribution licensing. Any entity where, whether obligated or not, may elect to generate, purchase, and consume renewable energy as per their requirement by one or more of the following methods. A, own generation from renewable energy sources. There shall not be any capacity limit for installation of power plants for renewable energy sources by entities for their own consumption, and such plants may be set up at any location in India, and power shall be transmitted by using open access, provided that generating plant may be set up by the entity itself or by a developer with which the entity enters into a power purchase agreement. B, by procuring renewable energy through open access from any developer, either directly or through a trading license or through power markets. And then not C, by requisition from distribution licensee, any entity may elect to purchase green energy either up to a certain percentage of the consumption or its entire consumption, and they may place a requisition for this with their distribution licensee, which shall procure such capacity, quantity of green energy and supply it, and the consumer shall have the flexibility to supply solar and non-solar. And then this pertains to the RPO, what we call as the renewable purchase obligations, which is in terms of section 86. And then please have a look at rule 5, green energy open access. Rule 5. Rule 5. Yes. To provide green energy open access to consumers of green energy, the appropriate commission may, if necessary, amend the relevant regulations made by it, and such regulations shall be consistent with these rules. So I have said I have given the right to the commission, and that they may, it is not even shall. All applications for access of green energy in this regard shall be allowed by the nodal agency within a period of 15 days, provided that only consumers who have contracted, demand, or sanctioned load of 100 kilowatt and above shall be eligible to take power through green energy open access, and there shall be no limit of supply of power for capacity consumer taking power under green energy.
Who is the nodal agency? Who is the nodal agency?
I'm sorry, no.
Who's the nodal agency under the rules?
That is the next rule. That has been defined, if I may read. Nodal agency. A central nodal agency shall be notified by the central government to set up and operate a single window green energy open access system for renewable energy. The central nodal agency shall set up a centralized registry for all green energy open access consumers, and all the applications related to green energy open access shall be submitted to the portal set up by the said central nodal agency. And these what follows is important. These applications shall get routed to the concerned nodal agency notified by the appropriate commission for grant of green energy open access. So once again, the power lies with the appropriate commission.
So if I understood you right, Rule 5.
Yes.
Provides for the appropriate commission to amend the relevant regulations.
Yes.
So basically you are directing now the commission.
No, please see the language. It says may.
Why would
may, and it says if necessary. If they find it is necessary, then they may.
No, then you aren't you transgressing 42?
No, this may be, here, for example, now I have conceptualized this centralized agency so that all
So therefore, this 42(2), which contemplates that the state commission is to do, appropriate commission is to do this job of regulating open access, is now taken over by way of Rule 6.
No,
by
it is only to bring uniformity. It does not take away their
I'm not
right.
doubting your, I'm not doubting your intentions. When 42(2) talks about the appropriate commission being given this task.
Yes.
If you were to frame a rule under the residual power and then say that this will be the agency now.
No, but I don't say this will be. Please, let me read the language again. The appropriate commission may, if necessary, which means there is complete liberty given to the appropriate commission. If they don't find it necessary, they need not do.
If there is already state commission's regulations,
Yes.
Where was the question of you framing rules?
If they deem it necessary, they will do it. Otherwise, they will not. Please look at the language used. It's a commission may, if necessary. So there is complete discretion.
All right.
Then
The last word is and such regulations shall be consistent with these rules.
it begins with if necessary and then says shall. If they decide that it is not necessary,
So
they shall
therefore,
be consistent with the does not even apply.
for whatever regulations that they are going to frame.
If they are going to amend, then it becomes.
So this will be the prevailing rule, isn't it? The regulations that they frame under 42(2).
Yes.
Will have to be in conformity with these rules that you have framed.
Only if they find that it is necessary.
So therefore, you have now become the agency, so the central nodal agency will now become the agency.
No, for what purpose? It is only for receiving the applications. We have created a centralized agency, a nodal agency, so that it receives the application. We are only streamlining the application process. We are not interfering with the jurisdiction of the state commission to determine the tariff or to lay down.
Not just tariffs. 42(2) talks about providing open access.
Yes.
That
No,
takes,
we don't tell them when to provide open access. We are only streamlining the application process.
the regulator knows how much open access can be granted, in what phases it should be granted. That is a specialized part.
I'll give an example. If my lord, we were to have in this the registry here, one different window for filing application for each classification of writ petitions, and then we have about 42 windows. And I say that and the right to receive of the registry, I will say there shall be only one window, and once it is filed, it shall be routed to the relevant counter as may be decided by the registry.
That is
Then
if
what
you,
if it
that is if you
I
have,
have
a-
not left the complete, I
that
have
is if-
made the entire process easy.
that is if you have a supervisory power under the act. When under the act, you give this task.
Under Z, my lord, I have, as the central government, my lord, I have the object of ensuring that the sufficient amount of green energy is generated.
If you can show me from the Electricity Act, there is a provision whereby you can issue a general direction to all the commissions.
I have not issued any general direction. This is not a general direction at all.
The central government,
These rules have been framed with only 5 avowed objects. That is to bring in uniformity in the application process, to bring in regulatory consistency, to bring in transparency. Look, this is pan India.
I'll
which is
repeat,
what we have done.
I am not doubting your intentions at all. I am doubting your power. You may have the highest of the most laudable objective. Until the parliamentary law is amended and it confers on you the power to frame a rule.
I am observing that repeatedly we are going to the power. May I request your lordship that we go through the entire rule, and then my lord, I will justify how this falls under Z.
I will take your lordship through the rules, not just runs about another 1.5 pages. I will take your lordship through that and then justify that I am within the zone of set. Lord, please have a look at sub rule 3 under 6. The appropriate commission shall notify the appropriate load dispatch center as the nodal agency for grant of green energy open access for short term to be defined by the appropriate commission, and the state or central transmission utility, as the case may be, as the nodal agency for the grant of green energy open access for medium and long term. The nodal agency shall make available all relevant information regarding green energy open access to the public on the portal of the central nodal agency. Not the object of this is so that any investor, he knows everything, there is clarity, he knows where to apply, how much time it will take, who will be dealing with it, how much he has to deposit. But then please have a look at the procedure at 7. The central nodal agency shall prepare within a period of 60 days of the commencement of these rules a common application format for the green energy open access in consultation with the forum of regulators, and application for green energy open access shall be made in this regard. This forum of regulators is under section 166, where the representative of each state commission is present. It is not an independent, it is not an alien authority. This is a constitution of all the state commissions representatives sitting together. They are the ones who devise the application format. And then please have a look at the third sub-rule. The concerned, two, all applications for the green energy open access complete in all respects shall be submitted on the portal set up by the central nodal agency. The central nodal agency shall, by an order in writing, approve the applications for the green energy open access within a period of 15 days, failing which it shall be deemed to have been approved subject to the, this is very important, subject to the fulfillment of technical requirements as specified by the appropriate commission. When it comes to technical requirement, the regulatory commissions have complete power. I am only doing the streamlining of the process. That's it. So that leaves them with complete discretion. And then under the rule 6 and 7, sub rule 6 and 7 also will be relevant. Appeals against an order of the concerned nodal agency shall lie before the appropriate commission within a period of 30 days from the date of receipt of the order under sub rule 4. The appropriate commission shall dispose of appeal within a period of 3 months, and the order issued by it shall be binding on the parties. And then banking. Banking shall be permitted at least on payment of charges to the compensation.
This has got nothing to do with the processing. Banking has got nothing to do with processing. It gives a right of banking.
We only say that it shall be permitted at least.
Your argument that these rules are only meant to process the applications,
yes,
would not stand in the light of Rule 8.
No, Rule 8 I am saying that the banking shall be permitted at least on a monthly basis on payment of charges.
So if this was a rule which one?
I will let me completely read. Charges to compensate additional cost, if any, to the distribution licensee by the banking, and appropriate commission shall fix the applicable charges. So which means the fixing of the tariff is still with the commission.
Yeah, but the banking facility, you determine a minimum. If this is an if I have accepted an argument that these rules are only mentioned framed to ensure a smooth processing of the application, this power of banking is not available.
Then later, when I go to section 42, I will demonstrate how this is permissible. The permitted quantum of banked energy by the green energy open access consumer shall be at least 30% of the total monthly consumption of electricity from the distributor. This is not available. Then please have a look at the other ground of attack is 9. Charges to be levied for open access. The charges to be levied on green energy open access consumer shall be as follows. We have identified about 5 broad heads. I'm sorry, this was replaced. For the replacement, would your lordship have the amended
page 72. So you have now laid down guidelines for the levy of charges for green open access also.
No, I already identified the heads of charges. These are all existing charges. Some states had their own charges. I only streamlined, but I have not determined how much should be the charges. I only identified the heads of charges. But please have a look at the amended rule. It says the charges to be levied on green energy open access consumer shall be as follows: transmission charges, wheeling charges, cross-subsidy charges, standby charges wherever applicable, banking charge. These are all I have borrowed from the statute. These are not alien. And please have to listen. Other fees and charges such as load dispatch, center fee, and the scheduling charges, deviation settlement charges, as per the relevant regulations of the commission. So which means if a particular commission wants to have a specific charge, they still have the right to. I have only, all these A to E are existing charges, which are already identified under the existing act and the rules. So that whoever wants to invest knows what are the different heads under which he may be charged. What is the amount, it is still left with the state commission. And then the 10, 11, 12 are routine, I mean, it is only certification and taking. I don't think there is any tariff.
176E talks about the power for you to frame rules in respect of matters not specified. Isn't it? 176Z. 176(1)Z.
Yes.
Enables you to frame rules in respect of matters which are not specified under A to B, right? Please read 176. In particular and without prejudice to the generality of the power contained in subsection.
In particular, and without prejudice to the general, this is very important, without prejudice to the generality of the, there are principles on this, I can furnish authorities. Without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely, and then Z.
Come to Z.
This is
Come to Z.
merely because it is Z or Z, that does not mean any curtailment of my power.
No, if you're falling back upon ZD.
No, in the rules itself, I said it is Z.
So therefore, it says any other matter which is to be or may be specific, sorry.
Any other matter which is required to be or may be specific or may be prescribed.
Z.
But what is equally important is subsection 1. Now, your lordship, spare a moment for subsection 1. The central government may by notification make rules for carrying out the provisions of the act. So, lordship will see, I have got broad powers. So, what has been given by the parliament to the state commission is to provide open access to determine the tariff. No, I have not touched any of that. But please look at the.
If you are indicating the manner which the application will be processed, if you are indicating what should be granted, what should not be granted, short term, long term, what are the charges to be levied, you are controlling the entire open access.
Short term, long term, and
Rule 6 will note. You're talking about different kinds of access. Rule 7.
Rule 7 is mere procedure. It's only the procedure for the grant of the access. This is not a substantive provision.
No, Rule 4, the 7.4, the short term and medium open access.
I'm sorry, but which?
7.4, the short term and medium term open access shall be allowed if there is sufficient spare capacity available in the transmission system without any augmentation charges, whereas for long term open access, the transmission system may be augmented if required. You're directing
term and medium term open access shall be allowed if there is sufficient spare capacity available in the transmission system without any augmentation, whereas for long term open access, the transmission system may be augmented if required, provided that priority shall be given to long term in the existing system if spare capacity is available, and further open access for non-fossil fuels sources shall be given priority over the open access for the fossil fuel. Yes, if there is sufficient spare capacity, I am saying it should be used. This will not exactly falls under subsection 1.
You're acting like a supervisory body over the
subsection 1, I have got the power. If spare power is available and if the state regulatory commission is not using it, I am saying it's using.
In the matter of providing open access, the entire open access is gone by section 42. It gives the power only to the state commission to undertake the exercise of providing open access. Now you are a supervening body, a supervisory body, who will now frame rules, who will now create a separate nodal agency, who will now state what is the manner in which.
In this petition, this on the court will have to examine whether these rules are made as an enabling provision, which to ensure that any person who wants to enter into the domain of investing, into the domain of investing in generation of renewable energy, whether it is meant for making their life easy and to ensure that we have greater amount of investment coming in, and then we produce more green energy, and the consumption of green energy goes on gradually increasing. That is the exercise that needs to be done in the petition filed here. And even if you look at the subsection 4, it merely says where there is sufficient spare capacity. If there is sufficient spare capacity which has not been utilized, I am saying it must be utilized. That would fit into subsection 1 of section 176. Notwithstanding section 42, I will take your lordship once again to section 42. So 42 would be very title if your lordship should say under part 6. It says distribution of electricity. Below that, the sub-chapter title is provision with respect to distribution licenses. Yes. And it is under that chapter, distribution licenses. Now, we are looking at open access for everybody. It is not just distribution licenses, which is why I said there are 3 categories of obligated entities, which includes the open access consumer as also the captive generators. So we cannot look at 42 as giving power to the state commission to not allow even central government to decide anything. So in that light, may I read once again subsection 1 and subsection 2. It shall be the duty of a distribution licensee to develop and maintain an efficient, coordinated, and economical distribution system in his area of supply, and to supply electricity in accordance with the provisions contained in this act. And then what? Subsection 2. The state commission shall introduce open access in such phases and subject to such conditions, including cross subsidies and other operational constraints, as may be specified within 1 year of the appointed date by it, and in specifying the extent of open access in successive phases, and in determining the charges for wheeling, it shall have due regard to the relevant factors, including such cross subsidies and operational constraints. Your lordship will notice that the consideration for other relevant factors is confined only for the charges for wheeling, to the exclusion of, I would say banking. So therefore, not to for the petitioners to contend that when it comes to open access, that state commission alone can do everything, and the central government cannot do even as an enabler to bring in any rule which will make the access to open, reaching out to open access easier. So there is one more issue that I think you also. Now, your lordship now have a look at the grounds of challenge in the petition. There are about 4 grounds.
Yes.
Petitioner has challenged these rules on about 4 grounds. Not the first ground is that by reference to section 2(5) to contend that the central government as an appropriate government can deal with only with the subject which is stated there. Please, your lordship, have a look at section 2, subsection 5. Subsection 5 is a definition of appropriate government, which reads as appropriate government means A, the central government in respect of a generating company wholly or partly owned by it, 2, in relation to any interstate generation, transmission, trading or supply of electricity with respect to any mines, oil fields, so on and so forth. And 3, in respect of national load dispatch center and regional load dispatch center in relation to any works or electricity installation belonging to it under its control. The condition of the petitioners is that the central government as an appropriate government can make rules only in respect of these 4 items. Lord, that will not is something which will not sustain itself, because the term used here is appropriate government, but under 176 Lord, it is central government. As central government, I can make rules and the entire extent has been defined. So therefore, that is a ground which will not sustain itself. And then his next submission is that the rules, the green energy open access rules, has abrogated the powers of the state and central commission in determining the open access conditions and the tariff. So my respective subjection is I have not entered into the domain of the state commissions at all. I have only on the periphery whatever is required for streamlining to bringing in some regulatory consistency across the country. I have not dealt with entered into the area where the state commission can exercise its powers under section 42. Then what his 2 other grounds are, the third one is that the field is already occupied. But as I mentioned earlier, under the Electricity Act, the powers of different authorities, be it the central government, state government, it is not in absolute watertight compartment or silos. The object of the act is that all these authorities work in tandem. They govern in tandem to achieve the objects of the statute. And then what his last ground is that I have left nothing to the choice of, as a matter of fact, the expression used is in ground number 35, what the petitioner says, because the tariff and open access is an open occupied field, though electricity and because the central government under the rules has not left anything to the choice of the regulatory commission, which alone is tasked under the act to determine the tariff. I have not tested the tariff at all. From prescribing heads of charges to defining open access procedure to prescribing renewable energy purchase obligations, everything is mandated under the rule. Prescribing the heads of charges is not completely alien. These are all charges which are already existing in the system and in the statute. And I have merely defined the procedure to bring in some transparency and to bring in some certainty. And the entire domain of deciding how open access should be introduced, what should be the tariff, how the disputes are to be resolved, what is the appellate procedure, all these are left to the complete discretion of the regulatory commissions. But my respectful submission is that these rules are in aid of the open access generators. But I am surprised not that the petitioners have questioned it. It makes their life easy. Now there is a much more clearer system. People know within how to make an application, within what time it would be disposed of. There is a portal, there is transparency, there is clarity. So they should not, for filing a writ petition challenging the validity of a rule, there must be some cause of action which should enable the petitioner to question it. But I fail to see any cause of action narrated by the petitioner at all in this petition. How is he aggrieved by that? If he is aggrieved by the determination of tariff, then there is complete discretion to the electricity commissions to determine the tariff. Why is he even linking the rules that I have made? So my respectful position is that the petitioner who is has has not disclosed what is the cause of action that gives him a right to challenge the validity of this rule. Not if somebody was aggrieved, it would have been the regulatory commission to complain that, look here, central government, you are transgressing into my area, don't overstep. No, that is not the case of the regulatory commission. The regulatory commission has already determined, and it has got my rules say where even if it is a case of amendment, it says where it is found necessary, it may. So if it is not found necessary, it would not have done it. So therefore, one of the issues that your lordships will have to consider is whether this writ petitioner has got any locus standi to question the virus of this law. And my submission is not, he lacks that. Therefore, not my submission is that to summarize my submission, under the Electricity Act, there are different authorities, including the central government, which have got powers to achieve the objects of the regulation of the generation and distribution of electricity. Particularly bearing that in mind, subsection 1 of section 176 gives the powers to the central government, keeping in mind other provisions. So whatever power that have exercised under subsection 1 of section 176, as also clause Z of subsection 2 of section 176, is bearing in mind the contours of section 42. I have not entered the contours of section 42. I have left it to the state commission. And as I mentioned, this is all to just bring in the ease of business so that we have greater investment and greater production of green energy so that we consume more green energy and reduce the carbon. I'm grateful.
Pointedly, I'll answer. May I persuade your lordships to see the scheme of the act and how these rules are, not in direct transgression. May I persuade your lordships to see first the section 28 of the Electricity Act. 28, because all these sections will not begin. 28, your lordships. Kindly see, my lord, the 28(4), regional load dispatch center may levy and collect such fee and charges from generating companies or licensees engaged in interstate transmission of electricity as specified by the Central Commission. Lordships may mark. So the RLDC, my lord, is a central government entity directly controlled by the central government, but the transmission charges, the transmission of for the licensees engaged in interstate transmission of electricity as may be specified by the Central Commission. Likewise, lordships may see section 31 also for a moment, SLDC, because in green energy open access charge bill that I have impugned, my lord, SLDC charges are also, my lord, impugned. Now in that, lordships may see 32(3), my lord, 32(3). The state load dispatch center may levy and collect such fee and charges from generating companies and licensees engaged in intrastate transmission of electricity as may be specified by the State Commission. Then your lordships may see section 38 for a moment, 39 for a moment. Now, my lord, the KPTCL, which is, my lord, levying these charges on me, who is a respondent before your lordships, is collecting transmission charges under section 39 2D of the Act. Now, my learned friend ASG said, my lord, that under section 42, the charges pertain to only the wheeling. And there is a vacuum or, my lord, some lacuna or some hiatus there that there is under transmission charge yaar madbeku antilla. I have wriggled into that space. Now, lordships may see 39 2D is, my lord, 39 begins like this. State government may notify board or government company or state transmission utility, provided that state transmission utility is so and so, so and so. So in Karnataka, my lord, KPTCL is the state transmission utility. Now, the functions of the state transmission utility, I am reading, my lord, 39(2). The functions of the state transmission utility shall be, then, my lord, lordships may ignore all that. Now come to D, to provide non-discriminatory open access to its generating system for use by any licensee or generating company on payment of transmission charges. Now, my lord, it could have easily helped me to argue that nodi 42 nalli transmission charge haakbeku antilla, ivaru hakida ultra virus and nan argue madbodittu. I am showing to my lords that there is a specific provision to levy transmission charges under 39 2D And then lordships may see any consumer where such, now this is important, any consumer as and when such open access is provided by the State Commission under subsection 2 of 42, lordships may see the interplay between 39 and 42 on payment of transmission charges and surcharge thereon as specified by the State Commission. This is, my lord, the occupied field. Not 42 in isolation, 42 to be read with 39, because when I make, my lord, an open access application, I get open access to the distribution system for which I pay wheeling charges, though it may go against me insofar as charges are concerned. I have a duty towards, my lord, the court, honorable court, to point out that I also have to pay transmission charges. If those transmission charges are paid by them, recovered by them, I can argue, our pay madidare, avrige nam consumers transmission charge ge compensate, I can argue that. That's not besides the point. But I'm saying, if open access is provided, non-discriminatory open access is provided, any consumer as and when such open access is provided by the State Commission under so and so on payment of transmission charges and a surcharge thereon as may be specified by the State Commission. So therefore, my lord, to say that 176 overrules 42 and 39, the interplay of 39, 2D is to say that, my lord, that rules nal yenaruma. Then, my lord, lordships may see 181 for a moment. Learned ASG, my lord, read these 181, 179. May I persuade your lordships to see the analogous provisions contained in the chapters that, my lord, are under the miscellaneous heading. Miscellaneous antane one chapter ide. Adralli, lordships will see power of the central government to make rules, my lord, which my learned ASG read. Then your lordships will see 178 for a moment. There is also an analogous provision under 178 to ZE. Andre residual provision anta helodadre. Now I question myself, when you are saying central government has residual power, Central Commission also has got that residual power under ZE. Then lordships may see 181. This is most important. Now, my lord, under this, I read out to my lords that section 39. Under that, lordships will see 181 to, Lord, lordships get it, my lord? Payment of transmission charges and surcharge subsection so relating to 39. This is the function of the State Commission. Then, my lords, will see 42 also, all the provisions and sub-provisions within 42, the State Commission and the State Commission alone has been empowered to make rules and regulations. And therefore, my lord, I am saying, you have to come from 31 to 33 and to show that all these are not occupied fields. Then, my lord, the central government has to transgress 181 also. And then, my lord, come to 181 and say, there is, my lord, a void there. Everything is an occupied field. Then, my lords, will see section 86 now for a moment. 86 for a moment. Now, my lord, 86 1E. Promote, am I reading it, your lordships? Promote cogeneration and generation of electricity from renewable sources of so and so, and also specify for purchase. This is important, Lord. Also specify for purchase of electricity from such sources a percentage of total consumption of electricity in the area of distribution licensee. Now, this is, my lord, the total consumption can be specified. Now, kindly see, my lord, the rules. Now, this is the occupied field, and see how the rule step by step transgresses into the territory. My lord, I am reading the rules, the rule 4, rule 3, I'm sorry, rule 3. Rule 3 says the applicability. Pagination may vary, my lord. I'm reading the rule and showing the clear transgression. This rule, I'm reading with your lordship, 3. This rule shall be applicable for generation, purchase, and consumption of green energy as defined under so and so. Illi renewable energy and baride, green energy and baride. Green energy is defined, and green energy is defined to mean electrical energy from renewable energy. So that is, my lord, 1. Second, I just read, my lord, 86 1E to show that percentage can be defined. Now, lordships will see on and from the commencement of these rules, there shall be uniform renewable purchase obligation on all obligated entities in the area of a distribution licensee. Now, Lord, juxtapose this with 86(1)(e), the exact language, but just a tweak in the Lord, then own generation from any entity, whether obligated or not, may elect to generate, purchase, consume, so and so, so and so. Then, my lord, we'll see by requisition from renewable license, any entity may elect to purchase energy from certain percentage. This is, my lord, an occupied field. More importantly, your lordships may see the green energy open access for a moment and juxtapose this with section 42 to provide green energy open access to consumers. Now, my lord, just I persuade your lordships to see 39D that I read and just see the language, exact matching. 39 nalli state commission ಗೆ ಅಂತಿದ್ದನ್ನ ಇವರು ಬರ್ಕೊಂಡಿರೋದು. To provide green energy open access to consumers of green energy, appropriate commission may, if it necessary, amend relevant regulations made by it, and such regulations shall be inconsistent with these rules. Now, Lord, I halt here and say, suppose they are not inconsistent with that, and Lord, if learned AST's logic is to be accepted, that our align ಮಾಡಿ ಅಂತ ನಾವು ಕೇಳ್ಕೊಂಡ್ವಿ, ಅವ್ರು ಮಾಡಲಿಲ್ಲ. Then what happens, Lord? These rules prevail. These rules prevail because lordships may see under these rules, the nodal agency is defined. And if I have to get open access, I have to go through this nodal agency only. A central nodal agency shall be notified. Even for a moment, my lord, regulation is not aligned anta itkondrunu. Very next provision, central nodal agency shall be notified. It is not, my lord, may be notified by the central government to set up and operate single window. Then central nodal agency shall be a centralized registry for green energy open access, and all applications related to green energy open access shall be submitted on the portal of the so and so and shall be routed to the concerned nodal agency notified by the appropriate commission for grant of green energy open access. Appropriate commission shall notify SLDC, load dispatch center as the nodal agency, green energy so and so, to be defined by the appropriate commission. Then lordships may see procedure for green energy open access, and then come to banking, my lord, which your lordships, my lord, pointedly asked learned ASG to say that banking shall be permitted, shall be. But now suppose, my lord, the state commission decides not to grant banking. There is a mandate to grant banking. And if it grants banking beyond a period also, that is also mentioned. Charges are determined there, shall be permitted at least on a monthly basis on payment of charges to compensate additional cost, if any, to the distribution licensee by banking so and so, so and so. Permitted quantum of banking energy by green energy shall be at least 30% of the total monthly consumption. No charges. Lordships will see. Quantification. Now, if it is only a mere regulatory and, my lord, a supervised, not even a supervisory, or even a benign intent of the central government to promote, no, it is to say 30% shall be distribution licensee by consumers. Then, my lord, so specific under micromanagement to say, for the purpose of this rule, expression banking means surplus generated energy injected from the grid by any green energy opener shall be drawn along with charges to compensate additional cost. Then, my lord, comes the super regulation to say charges to be levied by green energy shall be as follows. And kindly see 9E. No other charges except other charges shall be levied. Lordships get it, my lord. Suppose even if they don't align them, this regulation say no charges shall be levied. Then, my lord, cross subsidy shall be as per the tariff policy notified by central government, provided so and so, my lord. This is an expression from the act itself. Then your lordships will see, my lord, the explanation there to 9. Lordships get it, not standby charges. Lordships get it, not new charges are introduced. Illi, these standby charges in Karnataka are not yet levied. Now, this is introduced through this regulation, my lord. Standby charges, wherever applicable, shall be specified by the state commission, and standby shall not be applicable if green energy open access have given notice of advance 24 hours before the time of delivery. Ishtu micromanagement. I'm not saying, Lord, it is not benign or it is benign. I'm not entering into that debate at all. Sometimes it may benefit, sometimes it may benefit the distribution licensee. But I'm just showing the micromanagement to which these rules go. Then, my lord, green certificate, lordships may ignore that. Then there is, my lord, an amendment brought about at next annexure, wherein, my lord, alli rule 8 ಗೆ banking I read to my lords. Illi provided that, Lordships get it, my lord, it is rule 3 of the amended rules, provided that the credit for the banked energy shall not be permitted to be carried forward to subsequent banking cycle and shall be adjusted. This is also micromanagement. Now, if your intent is only to be a kind of a post office or my lord, or an agency regulating this, how can this rule be provided that it shall not be carried forward? Then, provided that unutilized surplus banking energy shall be considered as lapsed at the end of each banking cycle, and renewable energy generation station shall be entitled to get REC to the extent of lapsed bank energy. Again, micromanagement, super micromanagement. Then, my lord, Lordships will see Ali, Lordships saw that no other charges shall be levied anta helo kade, innondu substitute aitu, rule 9 ige. Transmission charges. Then, my lord, now charges to be levied on green energy shall be as follows: 1, transmission, wheeling, cross subsidy, standby, banking, and other fee such as LDC fee, load dispatch center fee, scheduling charges, deviation settlement charges as per the regulations of the commission. Now, my lord, I am saying, suppose if the regulations provide for these, suppose they provide for extra charges, or they do not provide for some of the charges, like standby charges are not applicable here. By virtue of this, those charges get applied. Those charges get applied. Then, my lord, cross subsidy also, Lordships will see, provided that cross subsidy surcharge, I am reading the next rule, my lord, shall not be applicable in case of power produced from non-fossil fuel based waste to energy plant supplied by open access consumer. I halt here and say, we are all, my lord, hydro or wind generators. Waste to energy ke open access idu cross subsidy haakbedi ant idral bardirodu. Now, how do I compete, my lord? Impairing the competition. One class of generators are singled out and say, don't levy these charges on these consumers. This is again super management. Then your Lordships will see, provided also that additional surcharge shall not be applicable in case of electricity produced offshore wind projects which are commissioned up to December 25. What more, my lord? What more can be termed as a micromanagement? December 25 offshore project. Why? Because there is somebody who has commissioned that in 2025 and there is some offshore wind and supplied to open access consumer. Now, why I should pay all those charges and why that offshore user of 25 will not pay? Why this waste to energy project will not pay? Then, my lord, will say the amendment to the standby charges. Standby charges, wherever applicable, shall be specified by the State Commission. Such charges shall not be applicable if green energy open access consumer has given a notice in advance at least so and so, day ahead minus D1 being the date of delivery of power of standby arrangement with the distribution lines. Lord, I possibly cannot contemplate a greater degree of control and it is a tariff order, I would say. To sum it up, it is a tariff order, not a regulation, not a rule.
These rules be raised to section 107, the directions that the...
Yes, I'm coming to that, Lord. This direction is, my lord, 107, 108, my lord. 107, yes. That is, my lord, even I'm grateful Lordships asked me. Kindly see whom it can be issued. Central Commission.
But can't it be construed as the power that the central government possesses?
Yes. Now, state
because the word used there is in public interest.
Yes.
Suppose in public interest, can they...
I'm grateful, my lord. I'm grateful. Kindly see 107 and 108. Now, there is a specific division, federal structure being the basic structure, my lord. Central government can issue to Central Commission alone and state government can issue to State Commission alone. Clear bifurcation of federal structure, 107 and 108. Lordship made. Now, even I'm ready to presume and not admit that this is a direction under 107. Now, you could have issued it to Central Commission because the Act only provides issuance of directions to the Central Commission, and Act also provides that state government, State Commission. There is a watertight compartment as far as, my lord, these are concerned. It cannot be transgressed. Now, suppose, my lord, the state government will issue to central entity. If this is allowed, central can issue to state entity under state nor central go issue marbo. So this transgression cannot be allowed because, my lord, the Act itself in parliamentary wisdom, they have compartmentalized it. We may like it, we may not like it. And 39, my lord, I read that State Commission, transmission charges na ಇವರೇ determine ಮಾಡಬೇಕು, ಅದನ್ನ ಇವರೇ ಮಾಡಬೇಕು, State Commission ನೇ ಮಾಡಬೇಕು, ಇದನ್ನ ಇವರೇ ಮಾಡಬೇಕು.
Suppose central government wants to promote this green energy.
Yes, that, my lord, there is a way out. Yes, I'm grateful, my lord, Lordships, my lord. That, my lord, is section 3 and 4.
That is only stating a policy.
That is, my lord, the only way. Now, a state government can, under 107, issue a direction to the central commission and, my lord, say that central commission, suppose the
Interesting, that's a dichotomy. The central government can't have the power to promote energy which is supposed to be
There
in
is.
public interest.
There is, my lord, a power.
Any regulations which is for the betterment of the citizen?
Yes, it can, my lord, under 107, which your lordships just now pointed out, for interstate promotion of power electricity, they can issue direction. Not only that, lordships may see, they can make rules under the Electricity Act itself. Lord, 2005, Electricity Rules 2005 was made by the central government regulating the conduct of the captive power plants. The rules are made. I am not saying, Lord, they have rule-making power. And kindly see, my Lord, 181, what is the wide sweep given to the central government which can be used for promotion of renewable energy? I am entering the moral argument, my Lord. I am conscious that this could be, my Lord, a moral argument that the policy can be framed why there is an embargo placed. Now, lordships may see 86(1)(e) before your lordships, my Lord.
The functions of the central commission.
Yes. There is no, that is what, my Lord, is more crucial. 79, there is no function to promote renewable. Maybe a legislative lapse. The 86(1)(e) that my Lord saw to promote renewables is conspicuously missing in 79. So the promotion.
The state commission is given that function.
How
do you think that the central commission also would have the same?
Should have been given, my Lord. Again, a moral lodge.
Should be stated at all.
That's correct. That is correct, my Lord. This state now, all state now could matter. If all state in aggregate promote renewables, there is no other agency, supervising agency required to promote renewables. But what I am pointing out, my Lord, since your lordships pointedly now just the correct point, my Lord, is to see that the 86(1)(e) is conspicuously missing in the central commission's functions. Now, if the central commission, by advancing the same logic, extending the same logic, not learned AST read, by this logic, they can say under 79(1)(k), discharge other functions as may be assigned under the act until non-residual tondo, renewable promote madboda. It's an argument. But when the legislature consciously omitted something which it knows exists in 86, can you?
In 2003.
Oh, amendment agide.
This concept of green energy was not that big an issue.
The amendments are as latest as 2022. The amendments, the legislature is aware and they are signatories to the central international conventions. They are aware, my Lord, that the legislature is aware, my Lord, that this needs to be done. And but why, my Lord? I'm answering that question, my Lord, from this perspective. The distribution licensees in the state are control. The shareholders are the state government. Our realities, we know how much subsidy is there, farmers' plight. Then what is my complexion? What is demographic mix? What is my consumption pattern? What is my demand supply scenario? What is my administrative rank? KPTCL, my Lord, is the only cadre. There is no cadre to ESCOMs. Chamundeshwari, BESCOM, they don't have cadre. KPTCL is the cadre. There is the cadre organization. So I know what is the employee cost. So it should be left to me.
Suppose one state commission.
Yes.
Decides not to pursue the green energy process.
Yes.
Because they have abundant natural resources.
Yes.
And if they do fall back upon green energy, there may be a loss to them. Suppose they don't do that at all. Central government is powerless to do anything about it.
The central government, my Lord, can make policy, can give direction to central commission. Now, Delhi, my Lord, decided.
Central commission will not have the power to regulate the intrastate transmission.
Illa, 107, 108, they can't. That there's a watertight compartment. I'm Lord.
There's that vacuum that in a given case, certain state commissions can disregard the promotion of.
Yes, very true. Because Delhi, I'm giving the specific example of Delhi, my Lord. There is no renewable energy possible in that state. And they are entirely dependent on the coal power or, my Lord, the other power that is from the. Now, if there is this mandate, suppose the minimum purchase mandate imposed on a state like Delhi, there is no wind energy global, there is no renewable energy possible, hydro or any other energy possible. So they can purchase certificates. They can, my Lord, then purchase the green energy credits from other. There is a mechanism evolved in the country, even internationally evolved, to purchase renewable energy credits, renewable energy certificates. And otherwise, my Lord, a state, that is the precise point, my lord. If the state decides in my own realities, for example, my lord, a northeastern state where the entire generation is from hydro 100%, then you say from other yella renewable wind in the ishtogobeku, waste to energy in the ishtogobeku, they will not be able to purchase. My specific submission is, what is the health condition, fiscal health condition of my distribution company? What is the fiscal health of my transmission company? How my SLDC functions? What is my generation mix? What is the geographical reality? Is there a geographical advantage, disadvantage? If the renewable energy is mandated, whether my consumers have the capacity to buy it, for instance, not in states like Bihar, or not some state where the renewable energy may be mandated, 30% you ಮಾಡ್ಬೋದು. ಅಲ್ಲಿ consumers ಗಳಿಗೆ subsidized power irta irbodu. Whether the distribution company can give that kind of a fiscal support, whether the government is in a position to give that fiscal support. If this kind of a uniform structure is imposed on all states, then my lord, the state governments will be crippled.
So how does the central government promote green energy?
Yes, green energy, my lord, the investment lordships may see 79(2)(3) promotion in investment in electricity industry. And ee tara industry na promote ಮಾಡೋದು. That they will, my lord, make industrial policies to promote. And the best way that, my lord, the governments can help the industry is to allow them to remain to themselves. ಅವ್ರಿಗೆ ಫ್ರೀ ಬಿಟ್ಟು ಅವರು ಟ್ಯಾಕ್ಸ್ ತಗೊಂಡು the industries will decide. Not if suppose there is an industry potential, there is an investment potential, the government need not do anything. The investor knows where to invest, how to. Suppose there is hydro potential in Himachal, I know how to invest projects and, my lord, get there is industry promotion department, there is power department. I'll get incentives, subsidies can be given by the central government. But to transgress into the charges domain, tariff domain. Now, my lord, the one argument was that the tariff under section 62, that also, my lord, is crucial, because when the tariff determination function under 61 and 62 has been given to the state commission, it is an integral mix. It is, my lord, it is inseparable mix. Suppose I determine tariff. Now, lordships will see 62 1B. Now, one argument was that 42 creates a void. I showed, my lord, 39, but I'm again showing there is, my lord, a fulfillment of the void. The appropriate commission shall determine tariff in advance, so and so. For transmission of electricity also under 62(1)(b), if I allow, the whole idea was, my lord, of the Electricity Act was to distance the governments from the tariff. That's why I showed, my lord, PTC India. PTC India, the Constitution Bench judgment says the very conceptual edifice of the Electricity Act, the very idea was to distance the power generation sector from the governmental clutch and to give it to the regulator. And
preamble of the act does envisage promotion of renewable source of energy.
Yes, correct, my lord. And lordship, yes.
How is it to be implemented?
Yes, that is to be implemented through the regulatory commissions. Therefore, my lord, the tariff, if earlier, my lord, the governments only used to fix tariff, all tariffs, generation tariff, transmission tariff, consumer tariff. Subsidies also were provided by them. In the process, what happened, my lord? Because I am the adjudicator, I am the cause, I am the manager, I will mismanage it. So if there is a regulator, he will fix the tariff in a scientific, empirical manner. Then consumer will create it. And subsidy, lordships will see section 61. It also talks about the subsidy by the government and, my lord, how the subsidy utilization has to be done. Lordships may see 65 for a moment. There is no subsidy contempt. Now, this, my lord, provision of subsidy by the state government, 65, my lord. There is no analogous provision for central government subsidy. Again, if the state government requires the grant of any subsidy to any consumer or class of consumers in the tariff determined by the state commission under 62, the state government shall, notwithstanding anything contained, so 108, lordships may highlight, my lord, 108, pay in advance and in such manner as may be specified amount to compensate the person affected by grant of subsidy in the manner of state commission may direct as a condition for license or any other person concerned to implement the subsidy provided by the state government. Now, I question myself, not legislature knows that central government also has a role to promote, which your lordships are, my lord, pointedly asking me. But central government, the legislature, central legislature, not state legislature, central legislature thought it in its wisdom that there is no analogous provision required for provision of subsidy. And 86(1)(e), state commission has got a promotional role. 79, we consciously omitted it. The parliament omitted it. So therefore, my lord, the government, particularly the central government, was totally distanced from this process because the federal realities are that each state manages its own resource. They are responsible for their conduct of their distribution licenses and transmission licenses. They are all state government controlled entities. If suppose, my lord, the central government tries to superimpose something or to heavily centralizing tendency ಮಾಡಿ ಎಲ್ಲ ಒಂದೇ ತರ ಮಾಡಬೇಕು ಅಂತ ಮಾಡಿದ್ರೆ it won't work. Because I am not saying that it won't work in a workable sense. It doesn't work within the provisions and tenets of the Electricity Act. And my lord, development of market, 66 also may be seen. Appropriate commission shall endeavor to promote development of a market, including trading in power, in such manner as may be specified and guided by national electricity policy. This is the role that your lordships were, my lord, saying. You want to develop market, the central government has a role to to develop market.
Somehow I find it strange that the central government can't do anything to promote
By its own legislation, my lord, if they make this, no, central government can make, my lord. So there are many roles. I am again and again showing, my lord, several provisions. 61, your lordships may 61 nallu kuda tariff policy is, my lord. 61H.
Part 7 of the act only talks about tariff. That may not be a consideration.
Alla adu kuda that also, my lord, tariff for renewables. Now, when the 2003 act was framed, it is, my lord, I bow down to one, my lord, observation made by my lords, that in 2003 we never envisaged that power could travel beyond the state. Always thought, my lord, it's a standby power that is called, my lord, the decentralized generation. It is centralized, the within the area on solar generation ಮಾಡಿದ್ರೆ ಅಲ್ಲೇ ಒಂದು 10 ಹಳ್ಳಿಗಳಿಗೆ ಕೊಡುವಂತದ್ದಾಗಬಹುದು, wind ಮಾಡಿದ್ರೆ ಅಲ್ಲಿ ಕೊಡುವಂತದ್ದಾಗಬಹುದು. This was the conception of the legislators then in 2003. But over a period of years, my lord, the renewable power started flowing outside the state. Now I just, my lord, lordships allowed one application for IEX. I am supplying power to other states. There the central commission is IEX is a central commission licensee, and central commission can be given directions under 107. This way they can regulate. Or if you want, if the state government wants farmer subsidy to be given, they have to give it in advance. Otherwise what happens is farmers have to pay that subsidy. So entire scheme of the act is, my lord, to keep an arm's length distance from the state government and 2 arms length from the central government. Because central government has no fiscal exposure. Central government's exposure is entirely generation based. NTPC, NHPC, Atomic Commission, all the generating companies are their domain. Then, my lord, transmission, PGCIL, the Power Grid Corporation of India, then, my lord, the CTUs and other transmission networks that they have in Northeast. Other than that, distribution is not controlled by the central government. So this open access is again, my lord, if I go out of the system, I cause financial loss to the transmission licensee and distribution licensee, which are under state government control. If state government control, if the central government starts managing into these, micromanaging into these things, that my control over the state government's control goes in that sense, that, my lord, everybody they'll be cherry picking. I'll pick best of the generators and all these charges will be streamlined, very less charges will be fixed, everybody will be out. Then state government entities will suffer. So therefore, my lord, very consciously looking at the management structure, the corporate structure of these distribution companies and innate control vested in them by the state government, the central government has distanced itself. Otherwise, my lord, there will be conflicts. Now then the state governments will start saying that you give subsidy to me. You are asking now to promote renewables. Then you are saying no other charges can be levied. You are saying this nodal agency is created. In 2 days, I have to give open access. My distribution company lost 300 crores in 4 days. You give subsidy now. You have made the rules, you give subsidy. There is no provision under the Electricity Act to give subsidy by the central government. Or you float a scheme to help me under the... So this will be not the problem. So therefore, the subsidy structure, promotional structure, regulatory structure is heavily skewed in favor of the states. And state commission also being made the entire guardian of the investments of the regulatory space, the renewable energy space, the central government has been totally distanced from the tariff making, the entire tariff making and control making space. And lordships will see that state commission's appointment is also by the state commission, state government. Selection committee is also by the, everything is controlled by the state commissions, lord. And lordships will see, but then 86(4).
Read 176(2). What
Yes.
are the powers that they have?
Yes,
to
lord.
frame rules?
176, lord, I am reading.
A, B, C, D.
Yes, lord. 1. The time within which the objection and suggestion to draft national plan, that lordships may ignore. Additional requirement relating to capital adequacy, creditworthiness, payment of fees for application of grant of license, constitution functions of NLDC, then works of licensee rules under 67. Then, my lord, subsection 68. These relate to, my lord, the road construction, the transmission line construction, allowances payable to the members attending so and so, terms and conditions of so and so. Then functions and duties of Central Electricity Authority, salary allowance. Then form of, my lord, the authority of so and so. Lordships may see it skips. It goes to some other chapters. 42 to 86 is skipped entirely. I'll be only wasting my lord's time if I go on and on and on. There's something else. And in striking contrast, if your lordships were to see the state commission's functions for a moment, that space that we are, lord, now, and the space that is under adjudication is, my lord, the space from 39 on 32 onwards, that falls under 181 2G onwards, my lord, from 2G to R. Sorry, yes. So that space falls squarely within the domain of the state commission. And even in the rule making, now, my lord, the generic rule, of course, I am arguing on first principles, my lord, there must be judgments that if the residual power is, my lord, exercised, then it should be akin, uberime fide, that should be akin to the other functions that are enlisted above you. It cannot be totally alien and go and relate to another section. Now the residual power is relatable to 181, not relatable to, my lord, 179, 178 or 179. Sorry, 176. My apologies. 176. It is all relatable to 181. So the if, my lord, one can understand if the state commission says that I have residual powers and they don't even have residual, they have direct powers. And if residual powers are there, if they want to expand a bit and say something more than what is not conferred in this is being expanded, that, my lord, is not related at all. The entire space. Now, in juxtaposition, lordships may see how wide-ranging powers have been given to state commission. Lordships may see.
Come to section 79 for a minute.
79. Yes.
79 and this 86.
Yes, 79.
79.
Yes. One is, my lord, regulate tariff generating companies owned and controlled by
79C.
Yes, my lord. Regulate interstate transmission.
Now come to 86.
Yes, my lord. Yes.
86.
That is, my lord, C.
It says facilitate
intrastate.
Different between regulating the transmission of interstate and facilitating intrastate transmission and billing of electricity.
This, my lord, regulate and facilitate. Yes.
The Central Commission is not functioned with
intrastate. No, that is clear. That is a well settled proposition. A Central Commission is not concerned. Maybe the language is different, but
they use the expression facilitate.
No, that is because lordships will see because of section 42, my lord. Because under 42, there is not it's not a function, but it is an onerous obligation, a kind of a benign obligation placed under 42 to grant open access. So therefore, facilitate and hellik karana enu andre, lordships will see 42.2. State commission shall introduce open access in such phases and so as specified. Idukke adu relatable. This is relatable to that. Because in 42, they have specifically said you shall introduce open access. They have specifically said this.
79 does not contemplate wheeling as a function to be looked into by the Central Commission.
No,
it's only the State Commission.
No, I also showed to my lords specifically 39 2D. 39 2D. Now to provide non-discriminatory open access to its transmission system by use of any licensee or generating company. Now, my lord, I question myself, what specific to clear occupied field is impossible.
All right.
And SLDCs are also under the state control. Lordships will see transmission within a state, section 30. Now, my lord, it is even direct. I'm grateful to my learned friend. Lordships will see 30, section 30 for a moment. State commission shall facilitate and promote transmission, wheeling and interconnection agreements within the territorial jurisdiction of further transmission and supply of electricity by economic so and so use. Very direct, my lord. Then lordships will see 31. State government shall establish the center known as so and so. Then your lordships will see government company and so and so. Then state load dispatch center shall be responsible for. So compliance of that. Now even my lord 33. This SLDC in a state may give such directions which my lord lordships disposed of one matter. Lordships recollects there was curtailment of power. I argued that it is interstate. Lordship said no, there is a specific provision, specific power given under 33. My learned friend appeared in that matter. Lordships recollect that lordships relegated it to the state commission to be disposed of within 2 months. So, my lord, if that kind of transgressions are permissible, then it will, my lord, completely skew the act in favor of something which it was not originally designed to cater to. And then lordships will see grid standards, intervening transmission facilities, all this, then directions by the appropriate government. 37, your lordships may see. Now, 36, my lord, is even more interesting. Every licensee, am I reading with your lordships? My lord, every licensee shall in an order of 35 provide his intervening transmission facilities at rates, charges and terms and conditions as may be mutually agreed upon, provided that appropriate commission may specify rates, charges and terms if these mutually agreed terms are not discovered. So, my lord, and directions by the appropriate government. Appropriate government in this case is, my lord, this. Now, the investment of the central government into the act, investment not in the fiscal sense, my lord, investment in legislative sense is only in that exclusive areas. Engagement is only in those exclusive areas. That's all. Grateful for this.
My friend has left me only as a runner and he has been hitting sixers. Now, my lord, I'll be as short as possible without repeating so much as he said, and with the permission to file my written submission. My lord, I would request your lordship to go to section 2, my lord, definitions.
Yeah.
Yes.
2.5, your lordship will see. 2.4 and 5. 2.4 appropriate commission is defined. Means the Central Regulation Commission referred to in subsection 1 of 76 or the State Regulatory Commission referred to in section 82 or the Joint Commission referred to in 83. What is below the appropriate commission is defined. So also appropriate government under 2.5. Central government in respect of generating company wholly or partly owned by it, in relation to interstate generation, transmission, etc. And my lord, B, in any other case, the state government having jurisdiction under this act. They have made compartmentalized in such a way that everything is clear as to appropriate government and appropriate commission or a specified commission. Keeping this in mind, my lord, I would request your lordship to see only a few provisions, maybe repetition, but try to be as short as I said. Your lordships have seen 62. May I request your lordship to see once again. Determination of tariff. The appropriate commission shall determine the tariff in accordance with the provisions of this act for supply of electricity by generating company to a distribution licensee, provided that the appropriate commission may, in case of shortage of supply or electricity, fix the minimum and maximum ceiling of tariff for such purchase of electricity in pursuance of an agreement entered into between a generating company and a licensee, or between licensee for a period not exceeding 1 year, to ensure reasonable prices of electricity. B, transmission of electricity, wheeling of electricity, retail sale, etc. So when this is read along with the definitions, it's very clear, Lord, there is a compartmentalization of the power that could be exercised. Your Lordships were pleased to ask a very pertinent question to the central government, saying that however laudable your object may be, you have to show the power where you derive from the provisions of the Act. They were not able to show it to your Lordships. And the second thing which fell from this court is, what is the residuary power? Residuary power, my lord, if your Lordship would see the first subsection, it is inclusive and not exhaustive. So if you go to a residuary power, it should not have been provided anywhere else in the Act. Then alone, you will not, like in the Constitution first list, the last of the entries in 7th schedule, list 1, Union government will not, whatever is not provided field of legislation, Union government has that power. Similarly, my lord, this power can be exercised under Z only in a situation where there is no provision at all, insofar as state commissions are concerned. Now, my lord, there are two other provisions. 86. Kindly go to 86. 1. Subsection 1. Sorry, A. 86 1A, C and E. Lordship may just make a note. I will not read and repeat once again what is said. My lord, A is very clear and categorical. Functions of the State Commission determine the tariff for generation, supply, transmission, and wheeling of electricity, wholesale, bulk or retail, as the case may be, within the state, provided that where open access has been permitted to a category of consumers under Section 42, the State Commission shall determine only the wheeling charges and surcharge thereon, if any, for the said category of consumers. See, your Lordship read that, which is akin to other provisions insofar as Central Commission is concerned. Facilitate intrastate transmission and wheeling of electricity. E, my lord, promote cogeneration, generation of electricity from renewable sources of energy by providing suitable means for connectivity with the grid and sale of electricity to any person, and also specify for purchase of electricity from such sources a percentage of the total consumption of electricity in the area of distribution. Now, your Lordships are pleased to observe 107 and 108. Ask my learned friend to read those two provisions. Section 107 and 108. We are concerned with 108. Directions of state government. In any discharge of its functions, the State Commission shall be guided by such directions in the matter of policy involving public interest as the state government may give to it in writing. So it is very broadly given power, my lord, including in the public interest. They can do what they want. Commission is bound by the directions of the state government. The laudable object, my lord, the central government doing it for the entire country. State government, my lord, has specifically under 108 can give directions to the commission to promote public interest. That is what is stated in 108. Now, permit me to read two annexures in my writ petition 29091. Annexure D tariff order. In any case, your Lordship may take that. But in my case, it is Annexure D, page 72, tariff order. 23 there. Show that specifically.
Page number?
131, your Lordship may go directly. tariff order starts at 72. I request your lordship to go to 131. As determined above, my lord gets that. The transmission charges of rupees so and so per month is applicable for all long-term open access consumers of financial year 24, excluding renewable energy projects, for which separate order issued by the commission would be applicable. They have excluded me in that tariff order.
But they have issued a separate order now.
It is not a separate order. It is in the nature of some clarification. If your lordship, it is at 159. Next year, 159. What did it say? 8th of June 2023. Second subpara, if your lordship would see for a moment. However, during the implementation of the regulations, stakeholders have requested the commission for providing clarifications on various issues which are discussed below. Now, my lord, come down to 5. Para 5 at 162. Charges applicable under KERC terms and conditions for green energy open access regulation 22. Terms and conditions of GEOA regulation 2022 specify that open access charges that be determined by the commission considering the methodology specified for renewable energy. However, till the time the commission adopts and determines the charges in accordance with the methodology specified by FOR, the KPTCL, STC, etc., are directed to collect the following: transmission charges along with transmission losses are determined by the commission in its tariff order shall also be applicable for a transmission coming under GEOA. What is given, my lord, under a tariff order? This, my lord, by way of a clarification, they take it away. They don't make a separate tariff order at all. Now, my lord, Annexure D. Tariff order we have seen. Annexure E, your lordships have seen. 32.3, your lordship may kindly have. SLDC charges under 32.3E. 32.3. My friend has already brought to your lordship's notice. The State Load Dispatch Center may levy and collect such fee and charges from the generating companies and licensees engaged in intrastate transmission of electricity as may be specified by the State Commission. Yes, yes. Specified where I have already shown under 262. 262 we have not shown yet. No. Yes. Kindly go to 262. Specified. Section 2, subsection 62. Specified. My lord gets that. Section 62. Section 2, my lord.
Yes.
Subsection 62.
Means
Specified means specified by regulations made by the appropriate commission or the authority as the case may be under this act. Now, my lord, if your lordship would see annexure E, this, they say annexure E, pay according to A. That is a clarification. Show that particular para, take it out. Yes. That we read. Yes. By regulations and the rules. Yes. In that rules of the nodal chain. Only facilitating applications being.
Even if I were to accept your arguments regarding the central government rules, even if those go,
Yes.
the state regulations will still stand,
Tariff made by the state commission, my lord.
will stand.
Yes.
Now, that is more or less in consonance with
They have just copied that and said collect according to that. The state government
if I
says.
accept your argument.
Yes.
I'm ultimately going to say only the state commission has the powers under section 42(2).
Yes.
But now that the regulations have been framed in accordance with those rules.
No, my lord. It can't be.
We have already addressed an argument that there are regulations existing by the state commission which are overridden and amended by virtue of this.
Notwithstanding whatever is said, the state commission would have the power to consider organize.
They can make independent regulation.
No, whether they make or not, as things stand now, there is one set of regulations which are in consonance with the central government rules. So even if I were to hold that the central government has no power, the regulations that have been already been framed,
Yes.
though may have been copied, cut, copy, paste from the rules.
No, but they specifically say you pay under annexure A. That is the rules as per annexure A.
Like, suppose that regulation has not been framed.
They have to make afresh. Because state commission, my lord, categorically directs pay as per the central rules or regulations which are made, which are challenged under annexure A. The contention of the central government is it's only a nodal agency creation and to see that all the applications are processed smoothly. There should be transparency, etc. But in the guise of saying that, they exceed their limit and step into or transgress into the powers of the state government, following that state commission, my lord, and then giving it a direction.
The praise to quash both the central government rules as well as the
B.
KPTC, the regulations, isn't it?
Yes, yes, we have challenged both.
The heart of the ARC regulation is central nodal agency. Kindly see not the regulation of the state commission.
You're challenging annexure C.
Yes.
They refer only to their regulations, not to this.
Sorry, my writ petition.
Annexure C.
Annexure B.
C.
In my case, it is B.
Nonetheless,
B hakidira.
CL. Charges applicable.
in that, my lords will see the opening paragraph itself. The objective, of course, government of India has set up an ambitious target. Then they refer to rules is one aspect. Even in the substantive side, of course, that preamble that is, my lord, that logic have already noticed. But central nodal agency, they kindly see, notified by central government to be set up to operate so and so, so and so. Then lordship will see forum of regulators, again relating to the agency. The entire scheme, not just the definition, even the substantive problem.
That is why I said, now that the regulations have been framed by KRC, which are more or less as guided by
Central rules. Now kindly see Lord 3.
your argument will uphold this automatically.
No. 2 lordship will see 2. The long-term GOA shall be allowed in accordance with the transmission so and so. GOA, green energy open access ke barodu. Adralli, lordship will see just about 2. So I'm showing you. Anything not specified in the regulations but specified in so and so rules issued by MOP, provisions of the said rules will prevail. Lordship will see that. Page not that just before regulation 2.
Page number.
Nandralli 99.
55. No. Sorry. 58.
58.
Page 58.
Anything not specified in these regulations, but specified in so and so rules.
58 of what? 58 of?
Your petition. 56. 58. The one, the writ petition that my learned senior is arguing about. Ali. After definitions and just before criteria for allowing GOA and the regulation mail.
No, I have page 58 is eligibility criteria for applying for GOA.
Nande notebooks. This is not I don't know.
WP number.
11235.
22770, but I lecture.
11235 in your writ petition.
Just before the release number 2.
Annexure B, B for Bangalore. The rules. Lordship may see the rules in any writ petition. I don't want to confuse my lord.
Annexure B.
Yes, regulations which your lordships just now said that will get upheld with our argument alone. Regulations. In that, just above regulation number 2, lordships saw that.
Anything not specified.
Yes, anything not specified in these regulations but specified in so and so rules issued by Ministry of Power, provisions specified under the said rules will prevail. This is nothing but Lord, a tail end of that engine. And I am not even reading the preamble. Of course, that is heavily skewed and dense with the objective. It is only to translate those rules into some action they have made. But also, Lord, this is very clear. And also criteria for allowing GOA, not open access. They say green energy open access. Green energy open access andre green energy open access as defined in the rules. Lordships will see only not happily drafted, not because GOA itself is not a defined term, but they use that abbreviation. But again, GOA refers to the rules. And lordships will see eligibility for criteria for applying GOA. ಅಂದ್ರೆ GOA rules ಗೆ ಅಂದ್ರೆ ಇದು ರೆಗ್ಯುಲೇಷನ್ ಇನ ಇದು ಒಂದು ಓದಿ ಅಷ್ಟೇ. The engine is that rule only because the terms and conditions that are not defined they relate back to GOA because lordship will see these terms are not defined terms. GOA is not a defined term. It relates back to the rules again. And then your lordship will see categorization. Then your lordship will see procedure for grant of green energy open access. Then nodal agency, central nodal agency.
No, I'll hear the KRC. Let us see what they will say.
Yeah, let them clarify that.
Just saying this is only a bogey, last bogey of this.
These are the two main contentions I have raised. One is the power to interfere with intra-state. Not the whole of it under intra-state. It's only the state commission, appropriate commission defined, appropriate government is defined. 262 also gives us an indication of that.
All of you are only interested, all the petitioners?
Yes, only intrastate.
All of them are interested.
Yes. So far as he has taken 2 more sixers. Notwithstanding that, still I am not out yet, therefore I'll have to bat a little bit. Now, my lord, insofar as central commission, my lord, the contention is it's only relatable to nodal agency and facilitate the processing of applications. In the guise of that, they transgress and go into the power of the state commissions and as notified, my lord, and state government regulations or whatever it is. This transgression is what we are going to challenge on the basis that you can't utilize 176(2)(z), residuary power. Under the, there is a specific provision. Therefore, they could not have done it. I'm only on the validity of A and B, my lord. And that, and insofar as D is concerned, page 131, though I am specifically excluded, they say by a separate order must be an order like the tariff order, and it's clarificatory in nature. That is what another learned judge of this court has held. You can't do that. And that judgment also I have produced. Therefore, my lord, if A and B will go automatically, we get the relief insofar as payment of transmission charges, etc., etc. We are not liable at all as I am today. And they can't bring it indirectly by way of a clarification, which is held to be bad, my lord, by the coordinate bench of this court. That annexure K, I think, is the judgment I have produced. I will only give the page number. Your lordship may just note down. Kindly go to page 160, judgment annexure K, at 174. My friend has argued that matter. Yes.
Yes.
In that judgment, my lord, at page 191, 193 and 194, finally the operative portion. Last page. At 207, para 21.
Yes.
This clarificatory order cannot be issued in that manner without following the principles of natural justice is what is held. Now, in this case, my lord, they just give a clarificatory order. They call it as a clarificatory note. They call it as a separate tariff order. We are bringing you also into this gamut of whole tariff, payment of transmission charges, etc., etc. Therefore, the lack of power and, my lord, the fact that there is specific power in the state commission, what it can do. My lord, even central government cannot issue any directions to the state government to do it in a particular manner. If that be so, my lord, can you make a rule or a regulation using a residuary power contrary to the provisions of the very act itself? Lord, I'll file my written submissions, and this is the gist of my arguments. These are the 2 or 3 important points which contentions will not your lordship may deal with.
You're for? I am appearing for the KPTCL in this matter. And the distribution licenses. The transmission licensee also. Sridhar Prabhu always will have something to say, Lord, whenever I open my mouth.
Not only you, even for
But I have some other case appearing for distribution licensee also.
His own case.
he is uniform in obstructing you.
At least he should not interrupt you. Because you are supporting his case.
But he interrupted him also.
I know, Manoj.
He will support this more than
Anybody else?
Yes, I am going to support Manoj, what Mr. Sridhar Prabhu said, because I have not understood it. Now, Manoj, I want to, I'm sorry, don't mean it as it's only a joke, please.
After 5 o'clock, later.
Manoj, I want to make one submission on this whole issue of whether central government has the power. First, Manoj, I'll make that submission because I want to say, Manoj, that whatever in the scheme of this act, the act, my lord, is on top, the rules and then the regulations. It is not, the regulations are not independent of the rules. As a matter of fact, the regulations depend on the rules. And that is this mechanism of this act. If there are rules, then the regulations can't be contrary to the rules. The regulations can only be in aid of the rules. And for that, my lord, I want to show your lordship 3 provisions. Please see, my lord, the provision which is 176 first. Power of central government to make rules. 176. Yes. My lord, the first is the general power. 176(1). My lord has the act. My lord. Central government may by notification make rules for carrying out the provisions of the act. Therefore, my first submission, my lord, is the generality of the rules is very clear. To carry out the provisions of the act, the central government has the power. Now, please see 2. In particular and without prejudice to the generality of the foregoing power, these rules may provide for the following. Now, my learned friends all have argued, saying, oh, there are certain things which are essentially state-driven, and they are only state commission-driven, and the powers under those provisions can only be exercised by the state commission to make regulations. Now, please see the power of state government to make rules, which is similar. 180. The state government may by notification make rules for carrying out the provisions of this act. Therefore, the power of the central government and the state government in my respectful submission are in pari materia in order to make certain rules to carry out the provisions of the act. Therefore, my lord, in my respectful submission, the power vested in the government is far higher than the specificity with which it is expressed in Rule 2 of both of them. Because Rule 2 says in these you must make rules. But the general power to make rules is not taken away. Now, lordship may now see 181. State commissions may by notification make regulations consistent with this act and the rules, generally to carry out the provisions of this act. Therefore, my lord, as your lordships can see, the regulations cannot be contrary to the act and also can't be contrary to the rules. Therefore, the independent regulation making power of the state commission can exist only in a situation where there's no rule. And therefore, my lord, the central government making a rule which is consistent and uniform for the entire country, in my respectful submission, is an exercise of the rule making power. Whether one goes to the residuary provision or one goes to the main provision itself, which is the power to make rules.
So the substantive provision specifically gives this function.
Yes.
Relating to open access to the appropriate commission.
Correct.
Can the central government frame a piece of delicate legislation to overcome that substantive provision?
Well, the rules which are, now there are two parts. I see, that's ultimately their argument as well. Now, if you also look at section 42 on open access, there are certain provisions which provide that the state commission must do it. But how it must do it is left to the state commission there. What do the rules do? The rules enable the state commission to do it.
I read 42 like this. 42(1) mandates
Yes.
that every distribution licensee shall ensure that there's an efficient system of distribution.
Correct.
Now, in that system, the appropriate commission is given the duty, the obligation to ensure that open access is available to all.
Correct.
The generators.
Absolutely.
That is all that is to be done.
Correct.
So the primary function is of the distribution licensee.
Yes.
The secondary function is to ensure that there is open access.
Yes.
Once you have two bodies specifically created under the substantive provision, can there be anything left for the rule making power?
Yes. Well, that is my submission. My submission is in rule making power, the rule maker, my lord, has the exclusive power to make rules with respect to any part of this act.
Now, wherever it is prescribed, he may make a rule.
True, my lord. Now, your lordship.
Accept your argument. That means he can virtually amend the act.
No, he can't amend the act. No, he can't amend the act. He can only make rules which will enable the state commission to act in terms of those rules. Because then the state commission has to make regulations consistent with those rules.
Then 42 would have to be read, saying that the appropriate commission shall ensure open access subject to the rules that have been.
No, it doesn't say so.
No, but
it doesn't say so.
Accepted.
Can I request, my lord, look at section 40? I know, my lord, it's a nuanced argument insofar as the interpretation is concerned. I quite see what your lordship is saying. On first blush, my lord, my submission also was the same thing, saying what is left. It is everything to be done is by the state commission, but nothing is left. But I have a little more to say on that. Therefore, would your lordship look at section 42(2), my lord? First is the duty of the distribution license. Now, 42(2). State commission shall introduce open access in such phases and subject to such conditions as may be specified within 1 year of the appointed date by it, and in specifying the extent of open access in successive phases and in determining charges for wheeling, it shall have due regard to all relevant factors, including cross subsidies and other operational constraints.
So the entire obligation
of operationally making a determination of how to do open access
shall introduce open access.
Yes, yes.
So all aspects of open access, including the charges that are to be determined, is vested exclusively with the commission.
My lord, I would say the state commission is mandated to ensure that, my lord, ultimately this was a legislation which was introduced to ensure that you are now in a position to give open access. Now, question is whose responsibility is it to give open access? The responsibility may not vests in each state commission, because each state commission has jurisdiction over that particular state. Therefore, which is why your lordship will see different states have different methods of providing open access. Therefore, each state commission will determine that open access is necessary for the state, and as a statutory mandate, it is bound, if I may say so, to ensure that it is done within 1 year. But it can be done in phases, and therefore it cannot possibly be done throughout the state. It may be done in portions of the state, or it may be done first for water, then for wind, then for solar, or whatever mechanism you have, you can do it. But this does not take away the power of the central government to make rules, to overall guide the state commission as to how it must do, because your lordships will see.
For that, there must be a substantive provision under the act, which gives them that power to issue a guideline.
Which is why I'm saying, Lord, section 176, which your lordship saw, gives power generally to make rules. The generality of it is only curtailed by the fact that there are certain provisions in 176(2) which say these you must make rules. And that means no one else can make rules, which is why your lordship will see in 176(2) and 178(2), which is power of central government to make rules and power of state government to make rules, the specific parts which are covered for central government separately and state government separately. And in that, there cannot be a cross rule-making power except by one to the other. Which is why central government says, okay, in these only central government will do, in these only state government will do, but that is without prejudice to the generality of the power of the central government. Which means, my lord, in my respectful submission, the provision does not have to provide for it. The fact that the rule-making power exists for everything. Now, the rule-making power, my lord, is not with the commission. The rule-making power is not with the commission. Regulation-making power is with the commission. And which is why I said, in the scheme of the act, it's the act, the rules, and the regulations. And therefore, the regulations come last. If there's a rule, you must follow it and make regulations in terms of that.
I accept that proposition. There's no difficulty. But the rule-making power, shouldn't it be specifically conferred?
No,
it's a piece of delegated legislation.
Yes, yes.
Therefore, there must be that element of delegation for you to frame the rules.
Correct.
You cannot say I have a general power, therefore I'll frame any rules that I want.
No, it has, which is what it is conditioned by one thing. It is conditioned by the fact that it should be to take this act forward, which is what your lordships will see, for the purposes of the act. So the purposes of the act, my lord, are manifold. One of them, my lord, is also open access. Now, it is not as if the central government's power, my lord, is in any way curtailed in so far as making those rules. Which is why I'm respectfully saying today your lordships have the benefit of a rule which applies across the entire country, which ensures uniformity throughout the country and ensures that every state, my lord, or a state commission will make regulations in accordance with those rules. Now I ask myself, your lordships have, Maharashtra will have a different rule, Tamil Nadu will have a different regulation by the state commission. That is because there is no other guidance other than what is contained in section 42. Insofar as open access is concerned. Today, your lordships have a scenario where everyone has to ensure that their regulations are consistent with it. But it does not.
That my doubt is like 107. If there's a provision which confers power on the central government to issue a direction to all the appropriate commissions as a guideline or as a policy, like in section 3.
Yes.
Then I can understand. When section 107 confines the direction giving power only to the central commission, you're now expanding it to all state commissions.
There are directions that can be given by central government.
To the central commission.
To central commission.
Now, by virtue of this particular rule, you are assuming that I can trace it back to 107. You are now. No, I'm assuming for a minute that these rules can be traced back to 107.
No, I'm not saying that. That I can't say.
To uphold the rule, let us assume it is traceable to 107.
Then it can only be to central commission. In which way it can't be. Because 107 is central government to central commission, state government to state commission. Therefore, 107 and 108 is very clear. Central government cannot issue a direction to the state commission. Today, my lord, in rule-making power in my respectful submission is not a direction to anyone. It is simpliciter.
Rule 5 virtually says.
No, I know, my lord. But I'm saying rules not by the rule, by the very mandate contained in the act, which encompasses a requirement that the state commission must follow the rules. That is automatic. Therefore, it is not as if, my lord, the rule has to say that you must follow it. 180 itself says that you are bound to follow it. Therefore, there is no option for a commission to do, 182.
The wording of 108, 180 is, suppose there is already a rule in existence.
Yes, my lord.
Your regulation can't be inconsistent with that. But suppose there's already a regulation in force. Can you frame a rule?
Yes, my lord. A rule can be framed.
Not directly empowered under the act.
No, my lord. Direct empowerment in my humble submission is, you also may see two parts to it. One is where a section itself empowers the central government to make rules. It is not there. There's no difficulty. If that was there, then there would be no argument. Sridhar Prabhu also would not have said anything unless he would have challenged it also. But he's not. But the point really today, my lord, is the substantive provision is the first provision. The power to make rules is contained in 176. 176, my lord, contains the main power to make rules. And that is to carry out the provisions of the act. But being a central legislation, ultimately the delegate is the central government, or it could be the state government to make rules. To make rules, no one else has the power. It is either the central government or the state government. The power to make regulations is with the central commission and the state commission. Now, the central commission, my lord, of course, cannot go outside its regulation making power because your lordship will see the language there. It has to be consistent with the act and the rules. It is both for the central commission and the state commission language. Your lordship look at 178 for a minute. Central commission may, by notification, make regulations consistent with the act and the rules, generally to carry out the provisions of the act. And if your lordships look at the language, one lord says use the word generally. When it comes to the commissions, it uses the expression generally. But when it comes to 176, the power to make rules, there is no generally there. It is specific. You have to only to carry out the provisions. Therefore, regulation making power may also go to other aspects in order to ensure that the act is ultimately not given effect to in its fullest. But for the other side to say that the central government has no power to make rules because the power to make regulations, or maybe let us say one state does not make any regulations at all. It simply passes orders on the basis of which not open access is granted. There are no regulations. Then the question is, when a rule exists, can that order survive? Or when a regulation exists, can it be contrary to a rule made by the central government? Now, whether it comes under residuary power or, my lord, under the main power, which is 176(1) itself, the general power itself is sufficient because what they have done is not contrary to the act. Ultimately, my lord, rule-making power is only hedged. Either if it is extra constitutional, it is all right.
There's this argument.
Yes.
42.2 talks about the commission to
Provide
to
open
be
access.
master of anything in relation to open access. So suppose I accept this argument of yours. The state government can issue a direction or frame a rule contrary to whatever the commission has done. And the commission is bound to accept that. And
yes. But now we are now assuming that either the
that will be contrary to the substantive
no,
provision.
if your lordships kindly see, 42.2 says it is enabling. It is simpliciter enabling this.
Would look at it as an exclusive duty cast on them. Nobody is to share that burden. It's only their burden.
But if it had been a rule-making power and that had been specifically granted, specifically as your lordships are saying, specifically granted as a rule-making power, it is one thing. Now, your lordships are saying the delegate is first the central government and the state government under the act. The central government and the state government are superior to the state commission or the central commission for one reason, because they also have the power to give directions. And therefore, the state commission stands in this entire scheme of the act below the central government and the state government.
Even 107 and 108 don't say they're bound by the directions. They are only saying they should be guided by the
Guided.
directions. So
Of course, it is like saying.
I've said it is bound. Guided means they may take the guidance or they may.
No, they may. That leeway is certainly there, my lord, when a direction is issued under 107. But if a direction is consistent with the act, I would think, my lord, it may be very difficult for the state commission to turn around and say, I will ignore it. But anyway, let us say, my lord, the state commission says in the larger interest of the public, this direction can't be adhered to, and therefore I won't follow it. Possibly, my lord, that anyway we don't have to test. But today I'm respectfully saying your lordship need not see 107 and 108, but look at the powers under 176(1). And of course, there's another also provision, Lord. If your lordships look at the power to make regulations, specifically 42 is covered. Absolutely right, no, there's no doubt about it. If your lordships 181(2) P, Q, R, S, specifically they refer to regulation making power in order to give effect to 42. But the question I have, and I ask myself, my lord, is this: does this power, which is given specifically to the state commission, override the rule-making power given to the central government to the state government? In my humble submission, the answer can only be no. Because this regulation-making power has been very specifically said that it will be subordinate to the rules made by either the central government or the state government. Now, if it is subordinate and the state commission is bound to make regulations consistent with the act and the rules, and of course, I would respectfully say that a delegate like a commission must be invested specifically with the power. Which is why otherwise there would have been no.
My apologies for interruption.
No, sir. You interrupting, I have no problem. Payment of transmission charges and a surcharge under subclause 2 of clause C of section 40. I understand that. That is there, certainly there. The transmission charges, whether you can fix or not fix, I'll come to that separately. Today we are really on the question, my lord, of a larger issue, according to me. Today, because the central government rules have been challenged before your lordships, the question really is, if your lordships are going to set aside or not, according to me, speaking for KPTCL or BESCOM, it will make little difference, because simply by setting aside the central government rules, it does not mean that the state commission regulations will automatically go. Because it is one consideration which they've taken into account. Maybe they made it similar, but each of it has to be tested independently.
One is that particular clause which says, if there's something inconsistent with these regulations, the rules will prevail. Therefore, it is.
Which
it's
I would,
subservient, like you said, to the rules.
it is subservient to the rules. It is without question. Now, if it is subservient to the rules and the rules go, then that provision also goes. Ultimately, my lord, the regulations can't go simpliciter because they say there were rules and there are regulations, and therefore, if the rules go, the regulations go. So, I would respectfully submit that that may be an extreme argument to make, that simply because the rules go, the regulations go. But I would respectfully say, given the overall interest of the entire country, my lord, and of course, my learned friend may pardon me for speaking for the central government here. You have permitted me, no? Okay. I'm asking the ASA, and my learned friend is permitting me.
State and central government in this. He has permitted, he has also permitted.
Some comedy is good. Therefore, my lord, my respectful submission is, if the power to make rules, if it is said that the regulation making power is equivalent to the rule making power, and that you must place it on the same pedestal, then the argument on the other side is absolutely right, that the state commission, while exercising power, is exercising a power similar to the central and the state government. And therefore, the regulation making power will be equivalent to the rule making power. My respectful submission is, it is not so. The reason why the demarcation has been made in 176(2) and 170 in 176(2) and, my lord, 182 is only to make a clear demarcation between what the central government has to do and what the state government has to do. And in that, your lordships will find there is nothing that is contradictory. There are separate powers that you are supposed to exercise with respect to two. But the generality of the provision and the residuary provision, both, my lord, in my respectful submission, enable the central government to make the rules, which your lordships will find not even under the provisions of the constitution, where your lordships have scheduled 7, part A, part 1, part 2, and the union list, concurrent list. There's also a residuary power there. And also, my lord, this constitution also provides that on a concurrent list issue, there can be the central government which makes an act, and the state act which exists.
The only objective is there should be no vacuum.
There should be no vacuum, there should be no inconsistency. But what I'm respectfully saying is, the rule making power and the regulation making power cannot be mixed. If that is mixed, my lord, then it will almost mean that the state commissions have or are placed on a pedestal equivalent to the central government and the state government.
Or the role of the commission and the government are clearly defined, and there's no overlap. Assuming that there's no overlap, and there's already a rule framed with the state government, in that event, the regulations would always be subservient to the rule.
Correct.
And
And
to
if
this extent, I don't think
there can't be a doubt. Now, your lordship may test this note under Article 246 of the Constitution of India. If there's a state act and the central act comes later on,
repugnance.
The repugnancy on the principle, my lord, central act will prevail. So if there's a regulation made by the state commission and a rule comes subsequently, then, my lord, if the state commission's regulations are not consistent with the rules, in terms of 182, it will go necessarily. It cannot survive. The rules will survive. And therefore, my lord, the argument that the power of...
I accept the argument.
If you have, of course. Which is why I'm respectfully saying that each of the powers have to be seen distinctly. And the power of the central government cannot be said to be subservient to that of a regulation-making power, my lord, which anyway is subservient to the rules. And therefore, if it cannot be subservient, if, my lord, the power to make rules cannot be subservient to the power of the commission, then the rules have to prevail. Whether each individual rule is correct or not is another issue. I'm today, my lord, only on the larger issue of rule-making power. And if that rule-making power exists, my respectful submission is the commission's power to make regulations has to be only consistent with the rules. And there is no bar, unless, of course, there was a bar saying the power of the central government will not extend to the regulation-making power of the commission. That, in my humble submission, can never be there, because the commission acts ultimately under either the state government or the central government. And therefore, in my respectful submission, that argument which is being advanced, that all the regulations, all the power to make regulations are practically at the same level as the power to make rules, in my humble submission, is not correct. And therefore, I would respectfully say, on that principle, the rules must prevail throughout the country insofar as and ultimately, when your lordships come to banking or open access or anything, they are only enabling provisions. They enable and give guidance. And they tell the state commission that you must do these things. But how you must do it? I'll give you lots of a small example. Please see the banking provision. It uses the expression at least 1 month. Therefore, it very clearly says a state commission may, in a peculiar circumstance, let us say in a particular state, they are introducing renewable energy, like we did several years ago. It is catching up. And the state commission says, I will give 6 months of banking. Because we feel at this point in time, for solar, banking of 6 months is justified. You may be able to do it. It can't be less than 1 month. A state commission cannot tomorrow turn around and say, I'll only give 15 days. That would be inconsistent with the rules. Which is why, my lord, I'm saying that if you also look at the rules holistically, it is ultimately enabling rules. Rules which give guidance. Now, under section 42, there is no guidance. If your lordship sees, it says give open access. We leave it to you. If there's a rule which gives guidance and says you must do it, these are the charges which we feel are the only charges that can be charged. How much it is, you will make a determination. That determination will have to be made by the state commission, and that will be applied uniformly across everybody. Therefore, in my humble submission, the entire rule is really a rule for guidance, as everything is, my lord. Implementing agency is always going to be the state commission because it has to pass the necessary orders to give effect to those rules. And therefore, respectfully, the rule-making power cannot be confused with the regulation-making power, and the regulation-making power cannot override the rule-making power of the central government. That is on that issue. Agreed.
Issue today, so I don't want to carry it further.
Okay. Then, Lord, let me answer then Soham's case, Lord, which learned friend Holla had argued. I'll argue that and then I'll respond to this. Yes, sir.
In Holla's case, only the regulations are challenged.
They have only challenged the regulations, and their challenge, my lord, is on 2-3 grounds. I argued everything else earlier. After which, my lord, a new statement of facts was filed, and the lease agreement with the government of Karnataka was filed. On that basis, the argument was the lease is for 30 years. But that, my lord, really begs the question because the lease is for 30 years. What else is there? Namely, banking of 1 year or 13 months in that case. Banking is for 12 months with a grace period of 1 month. Is not something which was guaranteed for 30 years. And it simply provided that you will be entitled to banking on a yearly basis with a 1 month extra period. After which, my lord, they signed the new agreement, which had differing charges. After signing that agreement, that entire period is over. Regulations have come into effect. And in this entire scheme, my lord, if I may humbly submit, I can't think of the contract ultimately overriding a regulation or overriding an act. Now, so far as the section or the provisions of that particular contract is concerned, I can't think, Lord, as to how when a contract exists, you can advance an argument of promissory estoppel. Because today, they have waited for the entire 10-year period, paid the fees as per that contract, taken a 12-month, not a 13-month period. And that contract specifically has a clause which says it overrides all of the contracts that have been entered into. And today, my lord, really, those are contracts entered into with the distribution licensee, that is BESCOM or MESCOM or someone, and themselves. Now, that contract is very clear. And the state commission ultimately determines what is the banking that has to be fixed. And on that basis, the state commission has fixed the banking. And that banking, as per the regulations, is 1 month now, which has been done in my respectful submission after going through a full process of evaluation. Now, my lord, your lordship saw that report, Prayas report, which was commissioned, and for which also objections were called for. Whoever wanted to participate, participated, and thereafter alone, my lord, was the regulations framed. Therefore, that was criticized on the ground that no, but you have not taken into consideration our hardship. I'm sorry, man, that's not correct. If your lordships look at those provisions, and I'll also give your lordships a short note on it at the end, there is very clear examination of what was the rate 10 years ago, what is the rate today, what is the rate upon tendering, and when they discover price, and how the prices have fallen, which means prices don't fall automatically. Prices fall when the fixed cost comes down, which means not the cost of installation, cost of raw material, cost of putting up an entire project comes down, then automatically the price comes down.
I have one doubt in this.
Yes.
When they bank, it's on a particular date.
Yes.
So the rate that is found on that particular date is known to everybody. So irrespective of the banking period, whenever they ask for this banked energy, why can't you just pay them the amount that was prevailed as on the date they injected the energy? So then it makes no difference. They will not be able to make a profit. You will not suffer a loss. What is the harm in following that principle?
No, it's like this, my lord. There are two ways of looking at it. Why do they bank? They bank not because they don't have a customer for the excess energy. That is the reason they bank. Of course, the consumer argument, I don't think not really, it doesn't apply because banking can only be done by a generator. Banking is done when they have excess power and they inject it into the grid. I don't need it. And I don't use it. I may use it, I may not use it. Therefore, I say in 1 month's time, please take it back. I will give it to you. That, my lord, itself in my humble submission is quite a significant benefit to them because they can take it back because they can find another customer. If they find another customer who can take the power, they're entitled to do it. If you don't get it, then you get the certificate. That, my lord, is an equitable way.
Giving that you give them 12 months banking.
My lord.
Even it them to 12 months or whenever they want. Your problem appears to be that you will be buying power at a higher rate, whereas they have injected power when it was at a lower rate.
No, it's not a question of lower rate.
That is where you suffer a real loss.
No, I know, my lord. That's one of the issues. That when the demand is high, that is, let's say summer months, when the demand is high
For the banking
and the
period-
power is low,
For the banking period, you can levy a charge for keeping the energy with you. Then when they want to buy the energy back or when they find a consumer, you pay them that particular rate at which they were injected on that particular date. I think
that, my lord, is one way of looking at it.
The share market, when the rate or that is not followed in central commission.
something like that. I thought even if that can help them, if that can help.
My lord, now, my lord, there are two things. One is in ultimately making a determination. There are various factors which come into play. There are factors of price, my lord, which in my respectful submission, ultimately your lordships are not going to go into. While your lordship certainly can suggest that is a mechanism, my lord. In a rule-making method, which the central government has employed.
I was just curious to understand what would be the problem for.
I honestly can't answer the question. I'm not equipped to answer the question. And I would respect. That's solutions are determined ultimately by the regulator.
Because they will not make a profit out of this. You will not suffer a loss is what I thought.
No, it is ultimately, my lord, if there is excess energy, it is lost. Even for me, it is not like I can store it somewhere and give it to them like the share market. My learned friend says, I have shares, I can keep it and give it to him later on. Now, my lord, there are places which will say,
On real-time basis, not energy is consumed. He doesn't store it. There is no notional.
there's no
They directly consumer
consumer yaru kododu.
I thought the best way of defeating this method was either take it at discount, saying that when you inject it today, if it's 10 rupees and you ask for energy at a subsequent time, I'll give you only 8 rupees. Then they will not by themselves ask for banking.
No,
Now, if you give them this 12 months, then they'll take to take.
There's no anyway no 12 months. Now it's 1 month.
If it's 12 months,
Yes,
they're hedging their bets.
they're hedging their bets.
So that you can defeat by giving them a
That's one
lower
way.
price.
That possibly is one way of doing it. But ultimately, my lord,
That can promote this green energy business. I thought
Lord,
it would not be.
this argument of promotion of green energy ultimately becomes a question of profit, is nothing else.
No, if you can take away the element of profit, then they will stop asking for this.
Maybe, my lord. But that is, of course, my lord, I certainly take your lordship as a suggestion, which they can consider. The state commission can consider, the central government can consider. But ultimately today, given the contours of where we are, and not an examination having been done, and the conclusion having been drawn as to whether this is the only method of doing and the final determination having been made in the regulations and in the rules, that this is the method by which we will deal with excess power, which is left after the banking month. In my humble submission, neither can I, my lord, nor can anyone else agree or say that this possibly is a better method. But that, of course, not as if the court makes a suggestion, that is something which they can consider as a method, not to ultimately evaluate it. But that can't be a reason to either hold.
I'm not using that as a reason. The thought crossed my mind as to what is the harm that is going to be.
No, I see, personally, my lord, if your lordship ask me, I see your lordship's point, because ultimately it will ensure that everyone will say, okay, let's find a customer. Now, even during that period, my lord, of where they have excess energy, it is possible, my lord, ultimately it's open access. The whole concept of, if they are selling it to me, if they're selling it to, my lord, the transmission company or the distribution company, and say, please take my power, whatever they generate, we take, and we'll pay them for it. But they don't want it because, my lord, they possibly get a higher rate when they sell it outside.
They want to bank. This could be the way out. Saying that if you want banking just for 12 months, this is all that you will get. So that way, this hedging their bets and making a profit out of your infrastructure is defeated.
Correct.
They will stop this habit.
Absolutely. Absolutely. I completely, I'm saying, please see the reverse.
When they sell it to me, during the months, my lord, where they have more power, I buy the entire power. As Bescom or KPTCL, I buy the entire power. They say, no, we don't want to sell it to you because we get a better price when you go to the open market.
If they want banking, make that the condition. Then they will not want to bank the energy at all.
Well, I think he wants to say something. Yes.
Your Lordship, when they inject the excess energy into a grid, we use it to our customers at that point because we can't store it. What they want is later on, when the demand is high and there's no supply in the market, it is at that point that they want to take back the energy from us. So your Lordship is suggesting whatever is the rate existing in the later half, when the demand is high, let them pay that rate and take the energy from us.
At whatever rate they had injected,
Yes.
pay them that rate. Don't give them the energy, pay them the rate. Let them do whatever they want.
That will amount to purchase of energy, your Lordship. That will not be banked
They
energy.
will stop banking with you. They'll
That
stop
will not technically be banking at all because
Make that the condition, then they'll stop banking with you.
because they in that case, your Lordship, in the later half when the demand is high, we'll have no energy to give it to them because we would have purchased the energy at the earlier stage itself at the rate prevailing at that point of time.
Tell them we'll purchase energy only at this particular, anything excess you will pay.
The
They will
only issue that we will have in that case is there'll be no certainty. We don't know which generator will have how much excess energy in that period. We work on a certainty basis because we have contracted generators with us. We know what is the demand in that particular
also want to
period.
take a benefit, they also want to take a benefit.
No,
Nobody-
the problem is this, your Lordship. In the month of May, June, or say in the monsoon month, we know what is the energy that we are getting from our suppliers, from our contracted generators. If there is some excess energy and we are made to pay them, they'll supply to us and we have to pay them by virtue of this mechanism, then what will happen is we'll be left with surplus energy. We'll not have the demand to source that. At that point, whatever is the demand that we are already sourcing through our generators. And if we are to ask our generators to shut down so that we can supply their energy to our consumers, then we have to pay our generators the fixed cost also. Whether we take the energy or not,
I'm saying this, pass it on to them.
the fixed cost also.
See,
All those things, if it may be,
stop banking.
then they will not.
Then, my lord,
No,
then, my
no,
lord,
that way not
there'll be much stronger voices from the other side as to how you can do it.
No,
No, we are not. We are not.
No.
If that's an agreement beforehand, and they will suffer the consequence, then they will stop banking.
They'll stop bank. They'll stop bank.
That is all.
Like, my lord, now they'll say, like my learned friend in Brindavan says, I don't want to challenge. I want short-term open access. I don't want this banking at all. I'll do this and close it.
That they'll do.
They'll do it.
It's because they're corporates. It's just
But
don't make money.
ultimately, but from the point of KPT, we don't get any great benefit out of banking. Banking energy. Huh?
ESCOMs.
Or ESCOMs don't get any great benefit out of banking. We don't want to bank. If your lordship asks us, we don't want to bank. Please supply energy to whoever you want at whatever rate you want because it is open market. You can sell it at whatever rate you want, wish. Now the banking, my lord, is a special privilege granted to them.
It's an insurance policy for them.
It's a special, now whether it's for 1 year or 1 month, ultimately the regulator decides. And the regulator, my lord, having taken into consideration all factors, has decided that it should be 1 month. And consistently with the rules which say it should be at least 1 month. Therefore, in my respectful submission, while my lord, if your lordships feel that that is a better method, I personally see a lot of value in it from my point of view as well.
Ultimately decide. Yes,
But
suggestion.
that someone has to take a call on. Because ultimately, I think your lordships can either uphold it or strike it down. And if your lordships feel that there is a better method, it can be a suggestion that can be put to the...
It's beyond my domain, but I thought, I was just curious to understand whether that was possible.
These are all ultimately decided by bigger people than me, my lord. So I can't...
Somehow not it paid into obligation. That this kind of a injection point alle atte rate ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ 2004 2005 this kind of an amendment and ABT mechanism was brought about availability based tariff.
Give me that judgment.
Somehow not in the next regulations it did not find exactly what you are
PTCL contracts have to be subject to. One judgment I wanted to place, my lord, with respect to Mr. Ulla's argument. No, not this one. The last paragraph of PKCL.
PTCL.
PTCL.
This one is a regulation and 178 override 616 contract.
My lord may see one judgment which we have placed before your lordships in
this page number 236.
236.
235 starts.
235. In this or?
This one, Soham.
Yes.
This is.
In Soham's case.
Page 235. Yes. This is 92.2, my lord. This actually answers the argument of Mr. Holla that his contract not should be given precedence. A regulation under there is a 92.2. A regulation under 178 as a part of regulatory framework intervenes and even overrides the existing contracts between the regulated entities in as much as it casts a statutory obligation on the regulated entities to align their existing and future contracts with the said I'm sorry, my lord, got that? Page 235 and 236.
Yes.
Then, Lord, there was an argument advanced by him that the central government regulations are made only for consumers. That, of course, my lord, I'll answer. I won't trouble your lordships again.
List of authorities made a submission.
On the list of authorities, I'll file a short note. Then they referred not to one judgment, which was passed by a learned single judge of this court, called Renew, where, my lord, this court, on the principle of promissory estoppel, had struck down a certain decision of, my lord, the State Commission, which was not a regulation, but a decision taken by the State Commission. Now, that was struck down because during the period of the contract, that alteration had been made. They said you can't do it, and therefore that was struck down on that ground. But Mr. Holla, my lord, argued saying, but you must take into consideration all factors before deciding it, which is why that report speaks of price and cost and how the price has fallen, because ultimately whatever we derive in terms of benefit is passed on in terms of tariff orders to the consumer. So if I pay more to these renewable energy developers, I will end up charging more to my consumers, because someone at the end of the day, my lord, it is the last person who uses power who has to pay, and no one else. Everyone else has to make profit. Renewable energy operators have made profit now for many, many years. Therefore, the time has come to arrest it a little, to bring it to realistic proportions. That is all that is happening by doing all of this. It brings it to a scenario where there is some kind of equal buying power and selling power by everybody. And since my learned friend Lord is a socialist, he should uphold it.
He has tasted blood now, so he's become a man-eater.
This is, my lord, that 13th March. Anyway, this is pending in appeal, my lord, right now. The learned single judge's order. So I had appeared for the petitioners in that case, my lord. But that was on a case where it was a necessity, not a case of this kind.
ARC, you have anything else to say?
Transmission charges.
You have anything else to say?
Transmission charges have to just respond.
Can you find this?
Which one?
Reply to the additional statement.
The additional statement of the judgments, my lord, I'm just filing this. It's just a response, not and making a distinction between the judgments. This means transmission.
What is that? No, that was reply to the additional statement of facts. Very broad, I think. This is reply to the solution.
So, if I can speak, tell the honorable court the joke. He said, if you can charge a separate tariff for interference, you should charge in that. Personally. Now, my lord, on the tariff order, there were two parts. The first, my lord, was the statement that the first tariff order said it does not apply to non-REC. And subsequently, it was clarified it applies for REC as well. My lord, in my humble submission, that is not a new tariff order in that sense. It is simpliciter applying the same price across REC and RE projects and non-RE projects. It does not do anything else. The tariff order remains the same. Initially, the reason why this occurred was, and it was a clarification because it dealt with FOR, because the requirement was the forum of regulators will come out with certain basis, that is FOR. And therefore, you must follow that and make the tariff for the RE projects. Therefore, initially, the tariff order was passed saying it only applies to non-RE projects. But a clarification said, until we do this FOR, basis of determination, we will follow the same transmission charges. Now, my lord, there's no argument as to how it is going to be different. It can't be different. The transmission charges will be the same because you're using the transmission lines, whether it is RE or non-RE, it will not make any difference. And therefore, that tariff order is the first tariff order which continues. Now, you can't strike down the first tariff order, my lord, because they've not challenged the first tariff order. They are saying the second tariff order is really a new tariff order which would have required a new public hearing, a new determination. There's no new determination because we are not making any change. It is the same transmission line through which, whether it is non-RE or RE, the same transmission line is ultimately going to take your electricity. Therefore, the rate is the same. Now, there are a lot, of course, my learned friend cited saying, oh, there's one judgment of this court, which is Lordship Justice Pandit's judgment. But that was a case where the rate was changed. It actually underwent a change. And therefore, it said you cannot do it without doing a hearing. Here, there's no change. It's the same tariff. Now, my lord, now, my lord, in several cases, this court has already said that transmission charges should continue as it is until the FOR is decided. May I pass on those orders?
Also followed case in copy there.
They also sought for quashing. Not a challenge to the rules, but a challenge, but not also, in this case, also to the tariff order, I understand.
8-6.
Then, if the rules go, of course, many things may happen. That's a different argument. But if ultimately the rules stay and a challenge only to a tariff order, then this will remain. This is the order which will ultimately prevail. Because not right or wrong, not this order has now been passed by this court saying that the tariff order will continue until you make a determination of FOR. And there's a direction to make a decision in a certain time frame. If FOR turns out to be higher than this, then I don't know where everyone will go. Because today, if it is lower, of course, one may say the benefit of the lower figure should be given to them, which is what the court has also done. Ultimately, court said, pay the transmission charges as it is. If on the FOR determination, it is found that the transmission charges will be lower, you will have the benefit of adjustment. And not if FOR is lower, they'll get the benefit of that benefit. Today to say I will challenge, but it can't be a scenario where you find every single method to challenge a imposition of a certain amount of money, which is being paid merely a service charge. It is a service which we are providing. Now you don't have any other right other than the right saying earlier it wasn't there. Therefore, continue it in my humble submission can't be an argument. It is only a privilege. Privilege lasts as long as it is granted. If tomorrow it's withdrawn in accordance with law, it is withdrawn. And therefore, in my respectful submission, today, my lord, I would say that this judgment holds the field insofar as this issue is concerned, because it has protected all interests. It has protected the interest insofar as what the transmission charge is and what the FOR will be. If tomorrow the FOR is higher, then, my lord, they'll have to bear it. If it is lower, they get the benefit of adjustment from the date of the tariff order. And therefore, in my humble submission, none of these grounds are really grounds, my lord, which your lordships may consider as grounds to either set aside the rules or, my lord, to interfere with the transmission charge. I'm very grateful.
One submission.
Oh.
One minute submission. Submission is only one submission. But mention the rules. Of course, I go by the rules framed by the instance law. In my way, framing the regulation, I have followed the procedure. And in my regulation, I have clearly stated not only under 176(1). I have also said under 86(1)(b), 181, 39(2)(b), 40(c), 42(2), 86(1)(3). And I have issued a discussion paper, there was a publication. I have followed the complete procedure and framed.
That was before the validity of the rules were tested. Suppose the rules go. Then what is?
Only in the extent of that invalid rule in my.
Then it will be a case of.
Entire rules will not go. Because it is not as if I have the regulation will go. I have not copied the entire regulation.
Even if they succeed in the main prayer, they fail in the subsequent prayer, is what you are saying.
Yes, that's all. So my friend has covered all the points.
Yes.
Objection. Same thing.
In the submission is this, then when Sri Jnana Sinnappa said, this is holding the field now, that already the consent. Kindly see paragraph 7 and 8. it does not decide any question and lay down the law. This order, my lord, para 7, the respondent says, till such time she will charge you. Petitioner says, no. So this can't be a precedent, my lord, or law precedent. There must be a point determined when finally, my lord, an order is made. If same points are re-agitated in a subsequent batch, then this may be, my lord, coming in the coordinate bench of this call. But if it is by consent, it can't hold the field, it cannot be a precedent to that.
One more source of power, which I have provided in a statement of petition. But under the one, under the for not it's with participation in convention and implementing the decisions. So therefore, my position is that it is a federal principle that the power of the executive court extends to the power of the legislature. So even for implementation of the decision to augment the generation of the agreement. So there are three sources of power in this chapter. Number one is section 176(1). Number two is 172 section. Third is the power and release on the of them. And as far as 176(1) is concerned, not just as a corollary to what the language is telling is that it says the government may make rules for carrying out the provisions of this act. So therefore, entire gamut of the act, act of the power to make rules. And that is amplified by the language in subsection 2. It says, in particular, without prejudicing the generality of the foregoing power. Foregoing means what is stated above. So, what is stated above in subsection 1? In my notification, I have recorded two sources of power. In the rules that I have done, I say subsection 1 and clause here subsection 2. So, therefore, the subsection 2 very clearly says that what is contained in subsection 1 is general power to make rules, to make the provisions workable. So, without touching on the main power of the state commission to determine the tariff, without any of the provisions, I can make the rules. And that is what happens.
And when will you file your return submissions? You want me to release the matter again, or shall I reserve it and then permit it?
Lord, I'm so sorry, but I'm in the standby matter more than run out on
We'll
two.
have it some other day. I am tired today.
No, absolutely. I'm not going to ask for now. Lord, can it be on Wednesday?
All right, Wednesday.
Great.
Your Lordship, will it be 4:30 Wednesday?
Then we can.
Lord, could it be 2:30, my lord? Because 4:30 has not worked out auspiciously for me. So could it be 2:30?
I'll continue with 4:30 because I have 2:30 matters.
Lord,
At 4:30, I can sit till 5:30. 2:30,
Lord,
then I'll be a problem.
if it comes up at 4:30, I'll finish in an hour. But if
Take
you're
it up on 4:30. If you remind me at 4:30, I'll take it up.
very
Keep the pencil. Keep the pencil. Yeah. You can keep my notes with it. Your notes. You want me to? Yeah, keep it in the. Yeah. I have it in my.
I think this.